Chaudhary, my lord, I've been informed that she is out of station, my lord. Lordship may take it this matter after the vacation.
Item 3 on the
Three.
request made on behalf of MSB Chaudhary. Matter stands deferred to be listed again after 3 weeks.
My lord, similarly, in item number 2, Mr. Pathak is also out of station. Can it be taken on Friday, my lord?
Friday is the last day. What's the
On-
point? It will come after vacation.
Same, my lord.
Item number 2 after vacation.
Okay.
The request of Mr. KP Pathak. Yes.
My lord, on 12 of this month, Lord, petition was filed, Lord, challenging the appointment of the cancellation of appointment of Gauhati, Lord. That was filed on before 2 weeks.
You want it for listing for motion
Tomorrow, Monday.
tomorrow.
Lord.
Motion.
Yes, Lord.
Fresh matter.
Yes, Lord.
File when?
It was the 12th of this month, Lord.
12th of this month. All right. Tomorrow. Subject to defects being cleared.
Lord. Obliged, Lord.
Yes.
Lordship, I beg to mention a matter still before Lordship, 8 May 26, a section 11 matter. Notice was accepted by the councils. We are directed to serve copies to the respondents. We have served.
Let it come after vacation.
Lordship, this week.
This week not possible.
Lordship,
After vacation 2011. 27. 2007.
Please, Your Lordship. With the consent of the other side, I beg to mention item number 31. May be possible for today. It may be listed after vacation, Your Lord.
31 on the request made on behalf of the
Jai Sharma.
petitioner. Matter stands deferred to be listed after 3 weeks. Yes.
Please, your lordship. Lordship, I beg to mention listing of an admission matter after vacation.
After vacation, 20th of July. Sorry, 21st of July.
Lordship, 21st and 22nd, we have some. Let it be the 17th, my lord.
17th.
Friday, lordship.
Admission matter. Reply filed, not filed.
This is a 24 matter, my lord.
Reply filed or not filed?
The reply has
Not been filed.
7.
All right, 17th.
Lordship, like to mention item number 47. Lordship, earlier on 4 equations has come, but due to paucity of time, because it cannot be taken now. It can be taken as last item, time permits.
47.
47 for hearing.
We will take up.
Lordship,
I beg to mention listing for motion, Lordship.
When was it filed?
Today.
Today.
Friday, it might be.
Friday.
Right.
Thursday.
Thursday.
Yes.
prayer for listing for motion filed yesterday.
Thursday.
Wait, please, Your Lordship. In item number 2, with the consent from the other side, I would like to mention.
Item 2 is already mentioned.
22, Your Lordship.
Huh?
22.
22. Okay.
Yes, Your Lordship. IA has been filed in this matter, which has not come on record today, along with the main case. So, Your Lordship, the matter may be tagged along and come after vacation with the consent.
All right. Item 22 to be listed after 3 weeks, along with the IA stated to be filed by the.
It has been already filed, Your
petitioner.
Lordship.
You have the IA number?
2160 of 2026.
Along with IA number 2160 of 2026.
May I pray for a date, Your Lordship?
List on 24th of July.
23rd, Your Lordship.
23rd reply file.
Yes, yes, Your Lordship.
All right. 23rd.
Obliged.
May I please, Your Lordship? I like to mention for listing one WBC admission column.
Admission column 24th of July.
Yeah, please, your lordship. Tomorrow, some matters are listed in the motion column. That matter is similar in nature. May be allowed to tomorrow.
Tomorrow, have you filed it?
Yes, madam.
All right.
I would like.
May please, Your Lordship, for a motion matter listed to be on Thursday night.
If defects are cleared, yes.
May it please, Your Lordship? I beg to mention item number 24. It may be fixed at 2 p.m. Your Lordship. Because the engaged counsel, he is out of station due to some medical exigency in Dibrugarh. So he will join through VC, Your Lordship.
All right, 2 p.m.
Maybe the Lordship, Lordship, I'll like to mention item number 39. We have already circulated the adjournment request.
39 on the request of on the circulation, in terms of the adjournment slip circulated, matter stands deferred to be listed after 3 weeks.
I'll write for the paper.
Mr. Hor appeals for the state.
May I please, lordship? I'd like to mention for listing, lordship.
Listing what?
Read petition.
Admission.
Motion, sorry.
Motion matter. When was it filed?
Today, lordship.
Today. Thursday.
Deep development.
Lordship, with the consent of other side, I beg to mention item number 46. This is a hearing matter, some difficulties, Lordship. The matter with after vacation.
46 on the request made on behalf of the petitioner stands deferred to be listed after 3 weeks.
So prayer with regard to item number 23, my lord.
23.
The recruitment matter of Indian Oil, my lord. Lordship was pleased to call for some records, my lord. We are not being able to seek some time, my lord. Have you taken, is there 23? Can it be taken on 16th, my lord? Because along with 37 and 38 also,
16th.
16th of July.
Right, 16th of July.
Madam, either on 17th or 20th, madam.
17th.
17th.
17.
This is item number 23,
23, 37 and 38.
23, 37, 38.
Alright.
We are for 37.
Lordship, I am for 37 and 38.
37, 38. The request made on behalf of the IUCN. Matters 10 deferred to be listed on 17th of July as agreed to by the council parties. Mr. F. Khan for item 23, MSP Barua for
Lordship, 37.
37, 38.
Right.
Yeah, Lordship, I beg to mention for listing of a matter for admission.
Admission,
Lordship. It will be on 17th July. Lordship.
not 17th, 27th of reply filed, not filed.
Fine.
Reply filed. Then let it be on 6th of August. 6th of August,
Lordship,
July, 29th of July.
Lordship. Please, Lordship. Lordship, I beg to mention is the matter for admission.
29 July.
Meet please, your lordship. Is a prayer for listing special motion item.
Tomorrow, day after, whenever you want.
Day after.
Day after.
Obliged.
Thank you, Your Lordship. Lordship, this is also similar situated matter, Lordship. The petitioner has applied for Lordship preferential appointment in the year 2021, Lordship. Since he has not approached before this honorable court for consideration of his
Who's
representation, Lordship.
for respondents?
Please for time for instruction. Madam.
Instruction.
Lordship, I may be allowed to file fresh representation, Lordship, in terms of this order, Lordship. Because this representation was also filed in the year 2021.
Which representation?
The representation, Your Lordship, will file at page number 38. Liberty may be given to file a fresh representation.
You file, why you want a liberty? You don't press the petition, file a representation. Who's stopping you?
The-
Why do you want a liberty from the court? You're filing the writ petition before the court. You're not addressing the
No,
matter.
only in terms of this order, Lordship. Otherwise, this can be continued, Lordship.
Now then you wait for, what is this order?
Lordship, since the petitioner has applied in the year 2021 and approached before this court in the year 2026, therefore, Lordship, he has been allowed to withdraw and file a fresh representation and
Heard
liberty.
learned counsel for the parties, the petitioner is agreed that his case has not been considered, that he has not been considered for appointment under the Assam Public Service within bracket Preferential Appointment Rules 1999 and in terms of Article 14 of the Assam Accord. Stop petitioner claims to be an educated unemployed member of a family of a martyr, the Assam movement, who submitted his application as far back as 15/3/2021. However, the respondent authorities have not considered his case in respect of a grade 3 post which the petitioner claims for appointment in the fishery department. Submitted by the counsel for the petitioner that he had filed an application as far back as 2021, 15/6/2021, which remained, which was not redressed by the respondent. Therefore, he has approached his court. He submits that he would like to file a fresh representation before the authority is concerned, and thereafter the authorities may consider his case. Counsel for the respondent does not object to such prayers made. Considering the limited prayer made, the petition stands disposed of, permitting the petitioner to file a fresh application, ventilating his grievance before the appropriate authorities. It is made clear that this court, while disposing of the writ petition, did not express any opinion on merits of the writ petition, and therefore the writ petition is closed only on the prayers made by the petitioner. In the event such a representation is filed, the respondent authorities will endeavor to dispose it off within a reasonable period of time. Disposed.
If like once, if there
By a
subsequently,
reasonable period of time by passing a speaking order, redressing the grievances of the writ petition.
and liberty may be given to a post in case of rejection of the,
There
Why
is
you
a
want
way-
liberty again?
because otherwise,
We have already expressed no merits. We did not express anything on merits. Why a further liberty is required? Not required. MS DD Borman for state, MS Sutia for
As Sudhir, Fishery Department.
S Sutia for fishery department.
highly.
Yes.
This case we have applied for registration of my name, apart from Rajiv Gandhi University. That university is probably not recognized by them. And there is an order passed by the government of Assam, and that order has also been stayed by this honorable.
We'll issue notice for today. Heard Mr. A. Das Gupta and a senior counsel, assisted by Ms. B. Das. Issue notice return in 4 weeks. Anyone for health? Mr. Adhikari appears for respondent number 1 and 2. Pharmacy council you are representing?
No, I can.
No, pharmacy
of
council, the Council of India.
No,
Mr. Adhikari for respondent number 1 and Mr. B. Gugoi appears for respondent number 3, 4, 5, 6 and 7. Therefore, the notices in respect of respondents 1, 3, 4, 5, 6, 7 are waived. Extra copies will be furnished within a period of 1 week from today. Steps of respondent number 2 by speed post within 1 week from today. Respondents will complete their instructions and file necessary affidavit if the needs arise. If so, advise.
Why? May I please allow? My lordship, your state forest officers, similar kind of case, my lordship, page 21, man may be seen, my lordship, the lordship. Similarly situated petition is my lordship. Page 29,
20?
31. my lordship. Similarly situated petition. Your lordship has passed the order. Pursuant to that order, already appointment has been.
Yes.
Yeah, but he's praying for setting aside that clause 5.
But this writ petition is listed after, directed to be listed after 2 weeks. Was it disposed of subsequently?
Earlier, my lordship, I moved, but kindly see page 34, my lordship. This clause 5 was not challenged, only I prefer to withdraw and submit.
Then why are you pointing out the earlier order?
My lordship, similar case, my lordship, similar.
You have withdrawn that earlier writ petition. Why are you pointing out this one?
No, my lord. This is the current writ petition we got.
Page number 29 is pending or
Yes,
disposed of?
It's pending regarding 29 pending, my lord.
Pending. What has happened to 29?
Well, my lordship, after that order, already appointment has been made, my lordship. National appointment has been made,
This is the pen. There is no specific order.
my lordship. There is an interim, my lordship.
There is no interim.
Kindly see. It is made clear that in the event all the petitioners subordinate during the process prior to their case being considered promotion, they would still be entitled to any national benefit that may be available to them, keeping in view of their claims for promotion of their IFS cadre for the select year 2021. The claim of the petitioner would still be open. So based on that observation, my lordship, page 33, my lordship. 33 order has been.
What do you say, Mr. Regan?
But let me not, the lordship issue notice in this, Malad, let me final my instructions, Malad. Because here, not here, challenge that clause 5. Of the order, Malad. Is it 3?
This is also Forest Department.
Yes, my
Yes.
same similar.
Where is, who's for Forest Department? What instructions?
State of Assam, Lordship. The order they are challenging, Lordship, it's
State
by
of
the
Assam?
Union of India, Lordship. Annexure 1. Government of India.
Council for parties issued notice. Mr. M.R. Odigari, let it. CGC appears for respondent number
2.
2. Mr.
A Goswami.
A. Goswami,
1, 3, and
respondent 1, 3, and 4. Who's for 5? MS so-and-so appears for respondent 5. If the respondents are represented, notice of the waive, extra copies be furnished within a period of 1 week.
All right.
Released after the return of date.
Earlier.
Yes.
Chip, petitioners, they're employees of the cost of cultivation scheme. It's a central government scheme. I'll have to take a lordship to a few documents. Show the main issue is regularization of service. They have been appointed in a contractual post. It's a regular sanction post. They're appointed through proper advertisement, all by following all due process. But then after years of service also, they have not been regularized. So there is a representation from the director of the cost of cultivation scheme because it's a central government scheme. So central government is a sanctioning authority. So the director who has a control over the employees, the director of the cost of cultivation, he has written on several or 2 occasions to regularize the petitioner, but then till date nothing has happened. And unfortunately, what has happened recently that the union government is saying that these contractual employees now, though there are extension of service previously on several till date since 2010, but now the government is saying that you should come through agency. So once they come through agency, there will be break in service also. So that being the reason the petitioners are here, finally they had no other choice. That being the reason they're here. I'll take your lordship to the documents so as to establish the fact that it's a regular sanction post and all other employees previously appointed were
No,
the regular
for
employees.
today, what do you want? Well, issue notice.
And status quo, lordship.
Status quo on what?
For continuation of their service. Because they have been continuing. No one.
Where is the apprehension that they may not be continued?
My lord, I will just show the representation. My lord, may kindly see 141. Page 141. Para 9.
Yes.
May I read, my lord? That, sir, our authority has been continuously informing us that the ministry has been verbally at annual workshop or via telephonic conversation asking to convert the nature of our appointment from contractual to outsourced employees. But no such written order has been received at our end. Moreover, neither in the signed MOU nor in the revised MOU, there is any mention about the transferring the contractual employees to outsourced personnel. Rather, there has been a point regarding transfer of financial accounts to the implementing agency, maintenance of assets registered by the implementing agency, and much more, but no mention about outsourcing the contractual stuff. But the authority is only keen on performing the process that has no mention on any official document. So how it has come, my lord, there will be, my lord, kindly see page 117.
You will issue notice today. Who's for the respondents here? Heard Mr. K. Chaudhary.
May I request, my lord?
Mr. A.K. Dotto,
all right, number 1.
respondent number 1. Mr.
And for 2 and 3, Lordship.
Goswami,
A
Goswami
Goswami.
for respondent 2 and 3. Petitioners are presently working as
Computers
and
clerk.
clerks under the Assam Agriculture University. There is scheme. in connection with quotes, page number 6 of the underlying resolution. Comprehensive scheme for studying of coast cultivation in the principal crops in India, which is an integral component of the central government scheme, title, again within quotes, studies of inputs for agricultural economic policy and development. It's closed. Stop. The submission of the learned counsel for the petition that they are presently working in under the said scheme. They're presently serving on contractual appointment.
Contractual. It has been
What
extended.
is your apprehension?
Apprehension is that they are saying that now you'll have to come through agency. So if they have to come through agency, there will be break in service. So if they are continued in service, then there will not be any problem.
There is an apprehension expressed by the petitioners from the conduct and the information received from the respondents that their respondents are contemplating to re-engage, contemplating to continue the services of the petitioners through some agencies. So it is submitted that in the event their employment is continued through agencies, there is likelihood of there is likelihood of there being a break in service in their services. Accordingly, the counsel, the petitioner submits that the respondents be directed not to take any steps during the pendency of the writ petition or disengaging the petitioner or re-engaging them through any agencies. The counsel for the respondent submits
Lord,
that instructions, any instructions you have,
no instruction, but
submit that they have no instructions, they would like to complete their instructions. Let this matter be listed after the returnable date.
Lordship, if I may point out, Lordship, Lordship, in their prayer,
25.
there is a
Letter.
they have mentioned the letter 25/2021, which they have not annexed here, Lordship.
Page annexure 20, 170.
Let this matter be listed again on 29th of July. Till then, status quo be maintained with regard to the employment of the writ petitions.
Yeah.
Petitioner counsel will endeavor to take steps on the respondent counsel
Right.
within 1 week from today.
Hello.
I retired from service on 31 March 2025, my lord, on superannuation as next subedar from Assam Rifle. However, my lord, at the time of retirement, my lord, 1,81,000.
There is counsel for the petitioner issue notice returnable 4 weeks. MSB Sharma, London CGC, appears for all the respondents. Therefore, notices are waived, extra copies be furnished within a period of 1 week from today. Respondents may complete their instructions and file necessary evidence.
Maybe, my lord, here in this case, the enquiry report, my lord, as well as the disciplinary proceeding under challenge, my lord, on the ground of, my lord, malafide and violating, my lord, the mandatory provisions of, my lord, the disciplinary and appeal rules.
Why no appeal?
My lord, in fact, what has happened, we are challenging the enquiry report itself on the ground that the enquiry officer, my lord, whom we have implemented by name, my lord, during the course of the inquiry, by undue influence and coercion, took the signature of the petitioner, my lord, and thereby that has been used against me. Now, if your lordship sees the enquiry report, it is based on no evidence, no, my lord, documents, no witnesses, nothing. It is only based on my 2 statements, my lord, confessional statements.
Now,
which are-
what is the disciplinary authority Has they taken cognizance of the report?
No, my lord, I have not waited, but because this report is of 2026, 9 January 2026, but till date, no order has been passed by the disciplinary authority, my lord. But I am challenging the entire DP, my lord, on the ground that, my lord, 4 show causes has been issued in the same, my lord, disciplinary case.
Your DP has not come to an end. The DP comes to an end upon the disciplinary authority accepting or rejecting the conclusion.
My lord, what I'm trying to say, subject to lordship's permission, my lord, since the DP, my lord, and the inquiry, my lord, report is challenged on the ground of fraud, my lord.
Hypothetically,
Well-
if the disciplinary authority refuses to accept the inquiry report, what is your grievance? Where is your grievance?
No, what I'll show, my lord, that there is a predetermination, my lord, all along.
If the disciplinary authority refuses to accept, does not accept the inquiry finding,
My lord, lordship is correct, my lord, from
Then-
one
then where
perspective.
is your
What I'm
grievance?
trying to say, my lord, if I challenge the inquiry report, my lord, and the DP on the ground of, my lord, malafide intent and fraud, my lord, that will not preclude me, my lord, to challenge the same and not to await, my lord, the order of the disciplinary authority. Because this is a case of fraud, my lord.
Why are you not understanding?
I have understood, my lord.
The disciplinary proceedings as on date,
Yes.
you have participated.
Yes, I have participated.
The statement the submission which you're making that he had forcefully extracted signatures from you.
My-
When was that?
My lord, I have annexed those statements, my
When?
lord. Yes. This is, my lord, your lordship will see. Firstly, my lord,
No, when was it done?
yes, my lord, I'm coming to that. Page 59. This is, my lord, the notice by which I was directed to appear before the, my lord, inquiry officer on 23/12/25. And on the next date, my lord, the 23/12/25, this is the letter, my lord, where when I appeared before him, my lord, this has been recorded and my signature has been taken.
That is in 25.
23/12/25.
So what have
Thereafter
you
again
done?
your lordship will come.
What have you done to bring it before the notice of the disciplinary authority that it was?
No, my lord, I have stated,
Hmm.
my lord, the inquiry officer took my signature on the count, my lord, that you will be exonerated, you just put your signature, my lord. And there is another letter, apology letter, my lord, page 18.
Hmm.
Now, yes, my lord, 65. By page 63, I was again, my lord, directed to be present on 9/1/26, on the day when the, my lord, inquiry report was submitted. This is the notice on 63, and my lord, on 9/1 I appeared, and this is the letter of 9/1, this is the apology
So,
letter.
as on date, have you received any notices, show cause notice or notice
Yes, my lord, thereafter the
after
inquiry report,
after the departmental proceedings were concluded? I mean, inquiry officer submitted.
yes, inquiry, my lord, thereafter on the disciplinary authority, my lord, second show cause was issued to me, asking me to reply, my lord. The order of the disciplinary authority.
So, as on date, no order has been passed.
No order has been passed, my lord.
Yes.
My respectful submission is, my lord, this is not a, my lord, normal case where I am challenging the, my lord, on merit, my lord, of the inquiry report. I am not challenging on merit, my lord. I am
See,
challenging.
we are asking you the same thing again.
Yes.
You are aggrieved by the proceedings. Your grievance with regard to the proceedings will culminate only on some adverse order being passed by the
Lordship is
departmental
absolutely correct, my lord.
Now,
My-
if the departmental authority, the disciplinary authority as on date has not passed an order,
Right.
it would be, I mean, you are aggrieved with the process, but there is no finality in the departmental proceedings.
Lordship is correct, my lord. My humble submission is, Lordship will kindly appreciate, my lord. The inquiry officer is in the rank of additional district commissioner. And he, my lord, is duty bound under the rules, my lord, to proceed in a certain manner. And he has done
But
something.
That inquiry by itself
My lord.
does not
Lordship will kindly see what he has stated in the inquiry report.
does not saddle you with
Malad,
any
page
civil
67,
consequences. We are not concerned with that.
Correct.
Doesn't affect you, doesn't saddle you with any civil consequences. What it does is
I
that
understand your lordship's point.
ultimately it is
I
the
understand.
departmental authority. They may disagree, they may agree, they may partially agree. So many possibilities are there.
I understand, my
If
lord.
they disagree, if they
Yes.
say that no, we don't agree on this, go back and have a fresh inquiry. Then
My lord will
if
kindly.
they say that sorry, we don't agree with this, we drop the proceedings, then how does it matter? It
My lord,
loses its.
This is one of the, my lord, consequences,
Hmm.
but this is not the only consequence, my lord.
May not
I'm
be.
going to retire, my lord. Lordship will kindly appreciate.
may
Well,
retire,
at
but
least Lordship will kindly take cognizance of this.
no, we
my lord.
cannot take cognizance. We would not like to take cognizance. At this stage, there is no order by the department. of
That is correct, my lord.
Then
I'll take instructions, my lord, after the mediation.
Mr. S. K. Talukar, the petitioner seeks liberty to complete his instruction in the matter. Matter being posted immediately after reopening. The date to be fixed by the registry, Mr. P. Bora. For the state, Mr. Doctor for the Revenue Department.
I'm deeply blessed.
Order they can meet.
Second hour, we'll pass the order. We'll pass orders in the second hour.
Completed. For final disposal after the.
What is the grievance here?
Lordship, actually, here, the corporation GMC itself take a policy decisions to regularize its 1,560 employees in 3 phases. In first phase, they decided to regularize 500 numbers employees before 10 February 2021. And accordingly, they regularized 500 employees on 10 to 2021. But they not regularized other employees till now, Lordship. I have filed affidavit in reply in item number 13 because they filed affidavit in opposition to item 13. They are all connected matters. They are both are. So it would be up to vacation, Lordship.
Yes, respondents, what do you say?
Lordship, after vacation.
Why after vacation? What is the grievance here? What are your prayers here?
My prayer is to regularize our service and respondent.
Regularize.
Yes.
Your working is what?
In petition versus some JTO, some office assistant. In item 13, I am.
You are challenging which order? Are you challenging any order?
Yes, Lordship.
Where is that order?
Order dated 28/1/2021,
Page number?
26/1.
Page number?
Annexer I-44 in item 13, Lordship.
Item 13. Annexure 44.
Page number 44, Annexer I. Marshals of the approval of honorable. May I read? Lordship?
Yes.
In
You are regularized as regular Mazdoor.
yes, Lordship.
Then what happened?
But Lordship, the second phase and third phase, they have constitute committee, but not regularized.
No, these names at 44,
Yes,
they are
Lordship.
the petitioners
Yes, Lordship.
or similarly situated persons,
Similarly situated persons.
not the petitioners.
Who's what? These 500 employees already regularized.
They are
Lordship.
regularized.
Yes,
They are
Lordship.
similarly situated like the petitioners.
Yes, Lordship.
And then what happened?
Then Lordship, for Lordship then come to Annexer J.
In continuation to the earlier order dated 28/1/2021 and for the first disposal of regulation work of Gauhati Municipal Corporation in respect to the minutes of the meeting held in the Residence Conference Hall of Honorable Minister G. Sikra with representation from 5 union bodies of Gauhati Municipal Corporations on 26/1/2021, the following employer temporarily interested for updation of all files to temporary casual fixed employees working under GMC. The team will camp at Conference Hall, Panbajar from 6/2/2021 and directed to complete the work on before 7/2/2021. But this work is not completed till now.
There was an attempted mediation.
Yes, Lordship.
What
but,
happened there?
Mediation is not successful, Lordship.
Pleadings are complete here. Counsel for the party subjects that the matter be listed for hearing. The date will be February after vacation. Release. Vacation. What is the present status?
That in the similar matter where my lord, we had filed an appeal before the division bench in Rupduti Das, my lord, that the person who was working as a copyist in foreigners tribunal. Now the honorable division bench have my lord dismissed the delay condonation petition, whereby my lord the appeal stood dismissed. Now, yes, now the finance department has moved the Supreme Court, my lord, and that we are awaiting the instructions, my lord. And I am told, my lord, that a special leave petition has already been filed, but it has not yet been listed. And that is one aspect of the matter, but most vitally, my lordship will kindly appreciate because offenders is now no longer holding the field. So therefore, at the most, my lord, the petitioner may be required to prepare a fresh representation. Because if persons of offenders, my lord, these notifications came to be issued, whereby, my lord, the quantum of the minimum scale of pay plus other allowances were, my lord, granted to similarly situated persons. Now, because of the fact that, my lord, offenders is no longer holding the field, so therefore, my lord, all the consequential notifications will also cease to exist, my lord. Will cease to have any legal force, my lord, as on date. That is the two aspects of the matter.
It is committed by Mr. R. Borpusari that the appeal filed by the state against the judgment and order dated against the order dated 5/10/2023 in WPC 7131 of 2021 came to be dismissed on the grounds of delay, and the state is taking steps to file an SLP before the apex court. Submits that matter be posted after the vacations, by which time we will be able to apprise the court status of the SLP file. We'll list this matter again in the month of August. The date to be fixed by the registry.
And so,
none represents the petition. The matter is called up. Mr. Raj for the 5 minutes.
And so,
Next.
You are appearing in for the petition.
Well, yes, ma'am. Item 19. That was on next, ma'am, report 5. I'm the petitioner.
There is some SLB preferred, so we have deferred it. We listed in August.
all it.
Similar matter
appeal is pending before the Honorable Division Bench, which is fixed on 25th of June, Lordship.
Then it counts, Standing Council for Animal Veterinary submits that appeal preferred against which order?
The order of the appeal, I have the appeal number on.
Against a judgment passed in a by appointed bench, where the issues are similar to the one heard before this court. It's pending before the appeal court. Rate appeal number
Appeal number 156 of 25,
156 of 25. It is submitted. The matter is fixed on
25th of June.
25th of June. Hearing this matter again the month of August.
Okay.
The counsel for the parties will apprise the court on the status of the outcome of the writ appeal.
Lordship, matter after vacation,
That's what we said.
August, but July
August
16th.
is after vacation.
Lordship, July 16th.
Why? There is an appeal pending. What is the status? Yes. Revised family pension is not released. Why?
Because we have asked for the service book, Lordship. That is not available with the
Why do you want the
administrative parent
service?
department, Lordship.
Why do you want the service book?
Without that, we cannot proceed, Lordship. That we have made clear.
Where is the service book?
Is not traceable, maybe.
Reconstitute the service book
Lordship,
from the acquaintance roll.
already, yes, Lordship. Or regular pensions is getting, but she is claiming ROP rules,
Revision.
Revision.
revision of
I am getting pension, but on the basis of the old base scale.
the ROP
No,
rules
sir.
2006.
Already 14 years have been absent. 12 years.
But when the service book is not available, what steps will you take? You have to reconstitute the service book on this claim.
Lordship, given direction, time may be.
On all earlier dates, the government advocates are taking time for reconstitution of the
I have
Service
done
book.
reconstitution, Lordship,
Okay.
there for instruction of which,
instruction for what for?
and I am always place instruction.
But you'll have to take steps now that there is a claim.
Yes,
To analyze whether the claim is sustainable or not, the service book is required.
required,
Service book is lost at the instance of the department.
yes.
So you
We have
reconstitute.
considered, yes, Lordship.
What is the stage now?
Already pay has been revised.
Lordship, kindly see order dated
By
23.
NHS 6, the pay has been revised and AZ has been
Everything is
requested.
admitted, Lordship, only file is not traceable. Kindly see order dated 23/3/2026. We have considered everything. We have,
Because of not having service book,
we have constituted a search committee also.
Where is the revised pay order?
NHS 6. Page 18. For fresh pension order, the AG was requested. Earlier, pay was 14,100 basic. That has been revised up to 31,880.
On what? When the administrative authority has already sent Mr. Chakraborty.
Lordship. We had Lordship made this letter, Lordship.
And this is Lordship, my last instruction. Lordship. Maybe somewhere.
This is of March 2026.
You reconstitute it, we'll take up this matter in July as expeditiously as possible. The Accountant General requires it to verify it in respect of the endorsements, attestations, in respect of the grant of revised pension.
By an order, my lord, they will direct it, to reconsider.
Yes, we will.
Yes, yes.
It is already directed. I think there is.
Otherwise, they have, every day they will have sit time for insertion of that.
I heard Mr. D. Chaudhary, learned counsel for the petitioner, Mr. D. Chakraborty for the Accountant General, Ms. S. Sharma for the Health Department, and Mr. R. Musari, B.C. Musari for the BTC authorities. So, the petitioner's late husband was serving under the Health Department, and he expired. He died in harness.
Yes, ma'am.
He died in harness, and thereafter the petitioner was entitled to family pension, the pensionary benefits in respect of her husband. So the petitioner has been granted pensionary benefits, but not at the revised scale of pay in which, but the same was not calculated on the revised scale, which was payable to the petitioner. Stop. Being agreed, the petitioner is before this court. The respondents
One, two, and five.
the respondents 1 and 2,
1, 2, and 5.
1, 2, and 5, they filed their affidavit stating that they have already communicated with the Accountant General's office regarding the fixation of pay.
Not by, sorry, Lordship, not by affidavit, placing instructions.
In your affidavit, there is an averment. That is what we are referring. In the affidavit, there is an averment that you have communicated with the Accountant General. That is what you say. During the on liberty being granted, the Health Department as also the BTC Department has stated before the court that the appropriate authority in the administrative department has already sanctioned the revised pay, the revised pension, and the entitlement of the petitioner, and a communication thereto has already been issued to the Accountant General's office. The Counsel for Accountant General on the other end submits that in order to sanction release the revised pension on the revised pay scale. The service book of the writ petitioner is necessary.
Husband of the writ.
Husband of the writ petitioner to verify endorsements necessary and the attestations by the head of office and other relevant documents regarding the grant of the revised pay scale. Stop. However, the State Council, the Council for the Accountant General submits that after the PPO was issued, the service book has already been returned back. There is no copy available in the Office of the Accountant General. Council for the Health Department clearly submits that they are in the process of the service book has been lost as per instructions received, and they are taking all steps to reconstruct said service book. Which is said that several opportunities were granted at the earlier date, and the service book have been reconstructed as on date. In such circumstances, the respondents are directed to reconstruct the service book within a period of 30 days from the date from today. The direction is issued to the respondents 1, 2, and 3. Stop. Once the service book is reconstructed, then the same shall be forwarded to the Office of the Accountant General for necessary endorsements for release of the revised pension. So, let the respondents' health department apprise the court in respect of status of creation of reconstruction of the service book. Let this matter be listed again on 24th.
Some more time.
They're giving you 1 month. 24th of July. It is made clear that in the event the state has not taken steps to reconstruct the service book, consequential orders may be issued by the court. Answer. In terms of the earlier order dated 10/6/2026, Justice Prakanto Umar Deka, former judge of the Gauhati High Court, has submitted his written declaration expressing no difficulty or hardship. The written declaration under Section 12(1), the Arbitration and Conciliation Act, expressing no difficulty or hardship to act as a sole arbitrator, if appointed, to in respect of the issues to resolve the differences between the parties. Stop. Under such circumstances, the copy of the written declaration is available in the case record. Being perused the same, the appointment of Justice Prakanto Umar Deka, former judge of the Gauhati High Court, made by the earlier order dated 10/6/2026, hereby stands confirmed. Copy of this order be communicated to Justice Prakanto Umar Deka, former judge of the Gauhati High Court, by the registry of the court. The parties will appear before the arbitrator appointed on
Immediately after vacation, 3rd week of July.
why do you need 3rd week of July?
2nd week also.
Once the order is there, you must appear immediately.
Lordship, 2nd week after vacation.
No 2nd week. You appear on 4th of July.
Lordship, I will be out of the station any day after 5th.
Or the 6th of July.
Much obliged, much.
6th of July.
Same order.
Same order.
Much.
The same arbitrator.
Same.
Same.
Much.
6th of July. The other to be the contract. None appears for the petitioner on board. For the parties. Matter be listed in the month of July. The date to be fixed by the registry. Affidavit filed.
We have filed the affidavit. Deadline.
What is the state? What is the stand of the respondents?
If we have filed an affidavit there, we have stated that the petitioner is otherwise covered by the NPS because he was regularized the year 2006 by order dated 12/12/2006. And the NPS policy, we have also annexed the NPS policy therein, wherein we have, wherein the NPS policy says that, which is at page number 33, that whoever joins service after 1st February 2005 shall not be covered by the old pension scheme. So he has been covered under NPS scheme, and so far as his prayer goes, Your Lordship, he is asking for release of his retirement benefits. Now, we have stated in the affidavit that an amount of 16 lakhs, respondent number 1, Your Lordship, page 41, the affidavit filed by respondent number 1. In her NPS amount as on 31/3/2024 to the 16 lakhs 19,241, and she has only withdrawn an amount of around 52,000 only. So rest of the amount is still in her NPS account. He can withdraw, Your Lordship.
What do you say? What do you say?
Now, she was LD.
I know, but there is some amount standing in the name, in her name, in the NPS, under the NPS.
Right. No, Lordship, there was for LPS, he was not given any notice, nor he was given option. So
You are regularized in 2006.
yes.
You are regularized in 2006.
The letter so and so that there was only retrospective effect, but that was the fake letter, fake.
Huh?
Because they have stated that point was that letter, that means here it is page 16 in the header 16, and the letter is next. This letter was issued on 13 November 5. 13 November 5. And there was specifically is there that this letter has been concurrence of finance department. But they have admitted that even despite their effort, they could not find out that from the finance department no clarification that there was concurrence. Moreover, thereafter, I would say that since the petitioner did not get any notice that she will be guided by the new pension scheme, nor she was given any option that will you be able to are you willing to get the scheme of new pension? There was no answer. At no point of time she was asked, nor she was given option. Rather, they have clearly themselves admitted that for clarification, they wrote a letter to the.
When did you superannuate from service? When did you retire?
Lordship,
When did the petitioner retire?
retired on to 30 November 2022. And the main point, 4 point is lordship, on the same day, on the same batch, one was appointed, and after his retirement, he got the benefit of old pension scheme. We have annexed the copy. So on point of equality of law and parity, she must get the benefit as of the old pension. The person who retired, he also worked with the petitioner on the same batch he was appointed. And after retirement, he got the benefit of old pension. In our affidavit, we have submitted the page number 47.
There is no averment by the respondent with regard to para 4 of the writ petition.
We have submitted copy of the pension.
There are 2 affidavits, but none of the affidavit has stated anything. Para 4, there is an averment that is lettered at page 16. It shows that she was brought into regular cadre with effect from her date of joining. If that be so, then she has to be given the pension under the old scheme.
Lordship, that is what the original at page number 17 is not clear. 16 is a type copy. The question is with regards to that line as regular employees with retrospective effect. So earlier occasion when the matter came up, the question was whether this was retrospective or prospective. So the original order is very unclear, you know, say at page 17. And the department was also asked to produce the records. And the department has written back to us saying that the records are not fixed.
There is no reason to indicate that this order will be prospective effect.
Yes.
Because ordinarily it is prospective from the date of issuance of the order.
Yes.
Unless it is retrospective, for which there has to be an indication that it is a retrospective order. No order is issued saying that this order is prospective.
I understand.
Order has to be that, yes, it is effective from the date of issue, unless otherwise mentioned that it is retrospective with some entity. Yeah?
So that is what your lordship, the controversy arose with regards to page number 17.
There is no controversy.
So that is
The
why
controversy could be that there is no indication that it is a retrospective effect, but the controversy can't be that whether it is prospective or retrospective. There is something which is seen in the original, and if it is prospective, then there was no requirement of mentioning it is prospective and indicating the date of joining. Prospective would be from the date of issuance of the order.
On last occasion, records were actually called for, and the department has written back to us saying that the records are not fixed.
Then they will direct them to release the pension on this basis.
Because otherwise, the same other people from the this Pradip Gogoi and Sanatan Bhavat, they have been issued the PPO. They have been issued pension.
Then why the case of the writ petitioner has been sidelined?
In fact, the affidavit is otherwise silent on this particular aspect.
That's right.
To be very
Where is the averment that the 2 other persons have been given?
We have stated in the affidavit that there is no record, page number, para number, your lordship, in the petition.
All right, at least you give us the information whether persons at serial number 2 and 4 in page number 16 are granted PPUs.
They have annexed.
They have annexed.
In the writ petition.
Okay. So you verify and tell us whether this is correct or incorrect.
That is what we have stated in the affidavit, your lordship, that there is no record as such with regards to Sanatan Bhavat. Of course, I have to take instruction on the additional affidavit with regards to Pradip Gogoi, wherein they have annexed the PPO order of the Pradip Kumar Gogoi.
Mr. Borpuzari, is there any likelihood of records being available with finance?
Well, finance is not the employer, so definitely minority.
No, the letter at page 16 says it has the concurrence of finance.
So it has the concurrence of finance,
Right.
but if lordship may be pleased, because page 16, my lord, is a typed copy, and page 17 is a totally illegible, my lord, document. Now, if lordship may be pleased to take up page 23 of the writ petition. Page 23 is a communication with regard to pension. Here it is something different. If I may read it, my lord, it is from the Director of Cultural Affairs to the Pension and Public Defence Department. Subject request for necessary instruction regarding pension benefit in respect of Sonali Dr. So-and-so is the petitioner. With reference to the subject, I have the honor to forward here with the application submitted by Sonali Dr. retired so-and-so under this regarding pension benefit. In this regard, principal in charge of the college has furnished the service details in respect of Sonali so-and-so. The following data has been furnished in respect of Sonali. Now, Lordship will kindly see, my lord, this serial number 1 to 6. At serial number 1, it is stated, Srimati Sonali Dr. Devi had joined her duty on 92. My lord, it is admitted as LDS so-and-so rules on temporary basis, but her service was regularized by letter number CAE 42/0482 dated 12/12/2006. So if it is regularized on 12/12/2006, so naturally, my lord, she will come within the ambit of the new pension scheme. Now, this is letter dated, her regularization letter is, my lord, it is dated CAE 42/0482. Now, if we compare this with page 16, it is something different. Page 16, it is something different, my lord. Page 16.
Yes.
It is different. Now, we will go by the official record. So this is the true official record relied by the petitioner herself in the writ petition on oath. Then GPF contribution number 2, my lord, page 23, I am reading, my lord. GPF contribution for an amount of rupees 300 was made so-and-so. Then for the period with effect from February 2000, NPS contribution was made. Also, will kindly mark this, my lord. But serial number 3. Then for the period with effect from February 2010 to September 2022, NPS contribution was made in respect of Srimati Sonali so-and-so against PRAN account. So that means a regular account was created in her name.
No, there is no doubt that regular account is created because she is being considered under NPS.
NPS.
The only question is, when was she regularized?
See, therefore, this page 23 is explicitly clear, my lord. She was regularized by letter dated 12/12/2006. And it doesn't say, it doesn't come with any qualification whether it is, my lord, retrospective or prospective. And then if lordship may be pleased to take up the affidavit, my lord, affidavit in reply, my lord, filed by the petitioner of late, my lord. There, lordship may be pleased to come to running page number 45, my lord, with all respect. Running page number 45. That is the affidavit in reply filed by the petitioner. There, if lordship may be pleased to come, my lord, to paragraph 7. Paragraph 7. Where the petitioner's deponent begs to state that on anticipation of new pension policy, the petitioner opened an account for monthly contribution and made deposit up to March 2024. Now, if she has retired on 2022, then how, my lord, she could make deposit till March 2024? But since the petitioner did not get any notice, intimation regarding implementation of new pension scheme, therefore, due to urgent necessity, the petitioner filed application praying for partial withdrawal and allowed the amount of rupees 52,028 and 53 paisa. Hence, the petitioner felt assured that new pension scheme will not apply in her case.
Mr. Counsel, you
Everything
have
is, my lord,
enclosed page number 23 to the writ petition.
yes.
It shows that you were regularized on 12/12/2006. There is a document enclosed to the writ petition.
And my lord, page 23, serial number 5, my lord, this also tallies with the affirmation made by the petitioner in her affidavit in reply.
Yes.
An amount of rupees 52,028.53 paisa has been partially withdrawn by them.
Yes.
And my lord, serial number 6, my lord, Srimati Sonali Dr. Devi retired from service on 30/9/2022 afternoon. So this being, my lord, the official document. So if at all, my lord, the petitioner has to establish her case, she will have to lay, my lord, materials contrary and with an overriding effect against this document at page 23, which is not there in the materials on record.
What do you say?
Lordship, that they have admitted that my joining date is admitted. It is
Yes.
what 21/10/1990. Now the question is whether the pension is will be with a new pension scheme or the alternate scheme.
If you're regularizing
There,
2000,
in the letter Lordship, there is prospective or is there, but that is not clear. Not it is a fact because my service was without uninterrupted. There was no any break.
page number 23, come to page
Yes.
23.
23 I have gone is that
Serial number 1, here your date of regularization is reflected.
yes. In this regard, Principal of Police has furnished the service details in respect of the Sonali Dr. Here, so and so. Following data has been. Srimati Sonali Devi joined her duty on 21/10/19 as earlier. Some types on temporary basis, but her service was regularized with letter so and so 12/12/26. This is clear. But the point is that only the regularization is not, it is not, there is ambiguity because my past service was not already not taken into
Then you have
account.
to challenge the regularization order.
Not taken into account.
That regularization order will have to be challenged in that case.
Even as per their affidavit, they have said that they were also confused. So in their affidavit, they sought a clarification from the reform from the service and pension reform government, but
Who's for the State Director of Cultural Affairs? Please produce a copy of this order at page 23. Regularization order.
Also, that is what will produce in the university, 12/12/2006. That itself will actually prove everything.
As also the letter at 23. 23 had enclosed that copy of the regularization.
Yes.
So you produce this letter of 23 along with the enclosures from your record for perusal of the court.
Yes.
Let us ask for the
Lordship, may with your permission, that they in their affidavit there is a specific categorical statement that the answering deponent begs to say that the matter regarding giving personal pension benefit in respect of petitioner Srimati Sonali Dr. Devi was taken up with the ARTPPG. That means administrative reforms, training, pension, and public grievances. This department that they make communication to clarify under which this petitioner Sonali Dr. should be given benefit. But what they have been said, the cultural affairs department is advised to.
where is the order of regularization?
Perhaps they are not clear.
Where is the order of regularization
They have said
reflected at page 23?
that we said there are perhaps. Cultural department is advised to take action as part of the guideline and pay special action.
Let us see the regularization letter, Mr. Rava.
Constantly this is there.
Otherwise,
This has
we
been
are,
achievable of
the department is otherwise questioning the veracity of Annexure 4.
So you produce the Annexure 9, page 23 communication. Heard Mr. U.C. Rava, Learned Counsel for the Petitioner, Mr. D. Bora, State Counsel, Mr. R. Bhojari, Counsel for the Finance, and Mr. B. Chakraborty. Petitioner is seeking pension under the Assam Services Pension Rules 1969 on her claim that her services to regularized with effect from her date of initial joining, which is 1992, as per the communication dated 30th of November 2025. Stop. However, the copy which is enclosed in the writ petition is not legible. Therefore, it's not legible. Stop. Again, at the petitioner has also enclosed a copy of the letter dated 22nd of January 2025, issued by the Director Cultural Affairs Assam to the Undersecretary Pension and Public Grievances Department, wherein it is reflected that the services of the writ petitioner was regularized on 12/12/2006. So, therefore, if the petitioner's services was regularized with the communication dated 30th of November 2005, then the petitioner would have been entitled for pension under the old pension rules. However, if the petitioner's services are regularized, in terms of the communication dated 22nd January 2025, stating that her services were regularized with effect from 12/12/2006, then the petitioner would be entitled to NPS. So, the state has filed the pleadings are complete, pleadings are exchanged. The counsel for the state submits that the records pertaining to the communication dated 30th of November 2005 are not available. So, in that view of the matter, the court directs the state respondents to produce the original copies of the communication dated 22nd of January 2025, issued by the Director of Cultural Affairs, wherein it is stated that the services of the writ petitioner was regularized with effect from 12/12/2006. So, although affidavits are exchanged, the state has not, there is no clear evidence as to which of these two communications are relevant for the purposes of counting the date of regularization of the services of the writ petition. Further orders will be issued on the basis upon the said communication being produced with the court on the next date. Matter be relisted again on 7th of August. 7th August.
And so,
Wait. In the matter, as we have already filed our affidavit in opposition, we state that the application of the petitioner was incomplete and the caste certificate was not being produced. Whereas on the other hand, Lordship, the petitioner was able to show that the application was a part of record, and we have also produced the caste certificate. After experience certificate. After that, Lordship, on the last day, on 1/6/2026, this Honorable Court directed us to obtain the relevant record and the necessary instruction in regard to the application and the certificate. So that is been awaited. We have written our letter on 4/6/2026.
So Lordship, we pray for some time, Lordship, to obtain the relevant record and basically some necessary instructions in connection with the certificate. Lordship. Experience.
Yes. Counsel for the petition respondent, prays for further time. Complete his instructions.
And in
He prays for further time.
and in item number 30, Lordship, we have filed the affidavit where we have mentioned that candidate for the post of Anganwadi Watata petitioner has been forwarded to the office of the Director of Women and Child Development for approval, Lordship. And
16 further time for instructions in the matters released.
And another thing is there, the same post was sitting by both the petitioners, man. I forced the direct selections, my lord, and my learned senior friend
Let
for
him obtain the
promotion.
instructions.
So whether that post is promotional or not, my lord, that is another aspect. Because for direct recruitment, advertisement has been published, and that was not challenged by my learned senior friend, my lord. So that is another issue, my lord.
No, these two matters are connected. They are different subject matters.
I am opposing my learned colleague, my lord, because I am for direct recruitment, and my learned colleague has seeking promotion to the said post, my lord.
The State Council will also apprise the court whether the post of Anganwadi
Worker. Salir Bhui, Umargati, Anganwadi Center.
Huh?
Salibhui Kumargati,
Umargati, Anganwadi Center.
185 number.
This advertisement shows a direct recruitment.
Whether the post of Anganwadi worker in 185 number Salibhui Kumargati under
Anganwadi Center.
Under what Gaon Panchayat?
It's under my lord. Mankasar.
The district of
South
South Salmara, Panchayat, is a promotional post or a post to be filled up by director. His instructions we place before the court on the next date of listing.
Muscle.
My lord, the letter pertains to my lord, termination of the petitioner, my lord, who was appointed as a block data manager, my lord, after being duly, my lord, selected in interview, my lord. Page number 15 is the, my lord, call letter where he was, my lord, called for interview. And my lord, after being duly selected, my lord, page number 18 is the order of engagement, my lord. In the year 2012, he was engaged as a block development manager in the National Rural Health Mission, my lord. And in different times, he was in post in different, my lord.
Where is the termination order?
Termination order, page number 36, my lord. The allegation is that a Facebook page post was shared from his mobile, and that was as contains anti-national contents, my lord, regarding some.
Is it denied?
Denied, my lord.
You deny it?
Denied, my lord.
Where have you stated that?
My lord, paragraph number 7, my lord, that the child of the petitioner, my lord, the 3 years old child, my lord, and he was with the mobile phone, my lord, and accidentally that was shared, my lord, from his mobile, my lord. That is not the question, my lord. The question is, my lord, that the termination is, my lord, without, my lord, giving any opportunity of, my lord, principle of natural justice, my lord. There is no.
You are a contract employee.
Yes, my lord.
You have executed a contract.
That is right, my lord. But
then what natural justice is required?
My lord, this honorable court, my lord, division bench, this honorable court, my lord. I have submitted the judgment, my lord, in the case of Partho Pratim Soikia, my lord.
Not yet.
My lord, may I submit?
Yes.
Before that, my lord. Before that, my lord, a similar judgment, my lord,
of dishonorable court of a contractual employee arrested, my lord, Mrigan Kolita, my lord. Their judgment is, my lord, in the division by judgment is, my lord, referred. The Mrigan Kolita judgment, my lord, he was a contractual employee, my lord, and the Honorable Justice of this Honorable Court held that, my lord, in paragraph number.
You are referring to which division bench judgment?
Yes, this will Partho, my lord, Partho Pratim Soikia. I have submitted my WA 256 of 25. Paragraph 10, 11, 12, my lord. They were also arrested, my lord, on some allegations, my lord. They were also contractual employee. 10, 11, 12, my lord, may I read, my lord. Upheld the judgment of the of this honorable court, my lord. After having, may I read paragraph number 10.
Yes. Have you seen the judgments? So what do you see?
Contractual employee, my lord, and terms of, as per the terms of contract, my lord.
Have you seen the judgment? Judgment has made a categorical view that it is stigmatic that you have to issue notice. Do you have anything to say in this regard?
I have, my lord, provided a copy, my lord.
That was the contractual employee, and as per the terms of contract, he was terminated as per clause 9 of the terms of contract, my lord. That is in the termination order.
Regarding that, my lord, I had also submitted a judgment of this honorable court, my lord, in the 2004 2 GLT Dormeshwar Boishya, that even though there is a term, my lord, it cannot, my lord, be Dormeshwar, my lord, paragraph 14, 15, and 16, my lord. Dormeshwar Boishya. Paragraph 14, may I read, my lord, regarding this clause, my lord. Even though there is a clause, my lord.
No, that is what we are saying, that the facts of the case, what was there in this part of, what is that?
In the part of, they were, my lord, arrested, my lord, on the ground of, my lord, the allegation was that, my lord, some job card was of the sum of the beneficiary was used to grant the Prime Minister Awas Yojana to some other beneficiaries, my lord, for which, my lord, all the employees of the Gau Panchayat was, my lord, arrested, my lord, contractual employees, my lord, all of them, my lord. And this, my lord, honorable court, the single bench held that even though they are in contractual, the principle of national should be followed, my lord, and they should be reinstated. And after that, due procedure can be applied, my lord.
No, but is it a case that you deny that this was post was not given?
That was, my lord, admitted, but, my lord, from my child, my lord, I have mentioned in paragraph.
How can your child give a Facebook post?
That was, my lord, mentioned, my lord.
How can your child, how old is your child?
He is 3 years old.
3 years old child, can he give a Facebook post?
My lord, that was
what kind of an explanation are you giving before the court?
My lord, that was the, my lord, case, my lord, what have been instructed, my lord. And, my lord, if on the merit, my lord, that is, my lord, if he get a, my lord, chance of opportunity of,
no, that chance of opportunity, we are asking you, what explanation will you give if a chance of opportunity is given to you? That your 3-year-old child has given a Facebook post, anti-national.
Yes, my lord, that is, my lord, sometimes, my lord, the children are, my lord, they take the phone, my lord, or parents, my lord, and sometimes, my lord,
for that to happen, either you are saying that the anti-national post was available with you.
No, man, that was
for it to be shared.
Shared, man. That was shared.
Shared. So shared means it was with you.
In the mobile.
In the mobile phone.
In the mobile.
So you have received or you have created some anti-national post.
Facebook's, my lord, when Facebook is open, my lord, there is coming, my lord, news, my lord, some videos comes, my lord.
You explain exactly what has happened here. We'll see.
My lord, that is the, my lord.
That is not explained here. What happened?
Paragraph number 7, my lord. That is
paragraph 7.
Yes, my lord. That is, my lord. I have, my lord, explained, my lord.
This is hardly an explanation. Was playing with the mobile phone.
Yes, ma'am.
On what is the date of the post?
Date of the
Which
post,
date?
my lord, not mentioned, my lord. In the FIR, it is mentioned by 9/5, my lord.
9/5.
9/5 in the FIR, and FIR lodged on 4/6, my lord. After about 1 month, my lord. FIR, my lord. Page
You were arrested.
arrested, my lord.
Hmm.
And during my custody, my lord, the termination order was passed. So, my lord, only, my lord,
What explanation will you give?
my lord, that is the explanation. My lord.
What kind of an explanation is this? How will the authority decide whether you are responsible or not?
That is, my lord, it will be.
What is 9-5? 9-5-25.
9/5/25, my lord, 20. Yes, on the page number 30.
What was the time? What was the time of the post?
26.
9-5-26.
Page number 26, 25, my lord. 9/5/25, my lord. FIR, second paragraph. Page number 26.
Natural justice is not an empty formality. It is not that without giving a proper explanation as to how you are prejudiced, every order has to be interfered on the ground of natural justice. You explain your conduct before the court.
My lord.
How are you prejudiced by not giving you an opportunity?
But if the petitioner gets a chance,
Will you develop the reasons,
no, my
the
lord.
grounds?
No,
we
what
want
I
to
have,
hear.
my lord.
We want to hear from you.
Yes, sir.
What are your grounds which you will explain before the authority, which if the court is satisfied, that yes, had this opportunity been granted, petitioner could have explained his conduct. What are the grounds? That your 3-year-old child was playing with a mobile and shared a post.
That was the, my lord, ground. It was
Is that a ground? Is that a ground?
If, my lord,
Are you not considering yourself to be irresponsible? That you are handing a mobile phone to your 3-year-old child?
yes, my lord. That my lord, will be decide, my lord, by the authority, my lord.
Why should it be decided by the authority?
That
What
is-
stops the court from deciding it?
My lord,
You are
that-
praying for prejudice on the ground of not being issuing a notice.
Yes, my lord.
What will you explain? How will you explain your conduct once a notice is issued?
That, my lord, that situation maybe he explained, my lord, in the.
You explain in the writ petition, you explain before us what happened. We are entitled to examine it.
Yes, my lord. In the repetition, my lord.
Para 7 is not sufficient.
Yes, my lord.
Not sufficient.
Regarding, my lord, the time or, my lord, date, anything.
We don't know anything. You have not explained.
Yes, my lord. That may be, my lord, if my lord, he gets a chance, my lord, then he can.
No. We are
explain,
dismissing your petition for lack of grounds. A proper
my lord,
explanation.
regarding my explanation, my lord, if required, my lord, I will submit an additional affidavit, my lord, in details, my lord. Because, my lord, in the document I have just, my lord, mentioned the submit an additional affidavit.
Counsel for the petitioner submits that given the opportunity, he would like to file an additional affidavit, bring on record further materials in support of his contentions that further materials in support of his contentions. He prays for 3 weeks' time. Prayer wait is allowed, released after 3 weeks. MS A. Bora appears for the NHM.
Let me know.
Yes.
Yeah, my lord, the petitioner is a constable, my lord. And he was appointed in 2008, my lord. He married in 2008, April, my lord. And first wife, my lord, deserted him in 2018. And in 2019, my lord, he solemnized second marriage. And thereafter, my lord, government issued a notification regarding bigamous, my lord. Thereafter, the first wife filed a complaint. On the basis of said complaint, my lord.
Where is the notification?
Notification page, my lord, 20. of October.
So what was the punishment imposed?
Dismissed from service.
Dismissal.
Lost. And this case is covered by lordship judgment in division bench. I have given, my lord.
You have given. You had given it last time.
Last.
That the judgments keep disappearing from here. There was an earlier judgment. Trilok Singh. Have you gone through the judgment?
Lordship, I have gone through the judgment, Lordship, but one thing is that office memorandum of the state of Assam is subsequent to that, Lordship. So,
No, office memorandum does not say dismissal. It says compulsory retirement. Yes, page number 20.
Maximum up to compulsory.
It says up to it was violated major
so including
penalty,
legal penal action by the court of
including
highest-
compulsory retirement.
Has been given effect from the immediate effect. So Mary's here took place in 2019.
Even if Lordship, he could have sought permission, Lordship, at least he could have intimated Lordship. This is also a lapse on his part, Lordship.
Inquiry report, the inquiry report finding on the page 20 and 31 that the marriage was under compulsion. Because first wife deserted him along with his son.
You have preferred the appeal against the order of dismissal.
Lordship, appeal dismissed, madam. Page 48.
What is the status of your first wife?
She's living separately.
You're not, she's not claiming maintenance.
So she's claiming she filed maintenance case. She's getting my lord.
She's getting.
And 498 case she filed my lord. I was acquitted.
Now after dismissal, how will he comply with the court's orders? Where is the direction of the court for paying maintenance? Is it available here?
So order is not there, but in the inquiry report, she admitted money. She's getting 705
Maintenance.
7,500.
It is in the inquiry report, it is reflected, Lord.
But after dismissal, how will she get?
Lordship.
Second
How many years of service have you put in?
my lord, 2008, my lord. Yes. 16 years, 10 months, madam, from the date of appointment till dismissal. 16 years, 10 months.
That you will not be entitled to pension. Will not be entitled to pension.
If they give voluntary retirement.
Hmm.
If they give compulsory retirement.
Hmm.
But they may impose my lord other penalty also.
Other penalty, why should we interfere?
Exactly in similar case, my lord, Bombay High Court passed recent judgment, my lord.
No, no, Bombay High Court, Gauhati High Court has passed three judgments. We are aware of that. But here is a case of alteration of the punishment. We are not interfering with the conclusion of the disciplinary authority. But in a given case, we can interfere, we can alter the punishment. By assuming we alter it to compulsory retirement, you're not entitled. Are you entitled to pension?
10 years might be, my lord, the qualifying service. They may impose, my lord, minor penalties also by.
For that, we'll have to hold that the charges are not proved or punishment is so severe.
Otherwise, my punishment, my lord, by inquiry report, my lord, lordship and CPS 31, my lord. Findings of the inquiry officer, my lord. Case 31, my lord, on scrutiny of the my lord. Merit, my lord.
Yes.
On scrutiny of the above, it has come to light that it is a fact that delinquent so-and-so got married for second time with so-and-so as per the custom of Muslims Qazi marriage act without consent or permission or divorce from the first wife so-and-so, so though she is now living separately from the delinquent. Srimati so-and-so also said that she is the first wife of so-and-so and their marriage was solemnized in the year 2010. They had a son who is 10 years of age. Now she is living at her parents' home without her son and under the care of delinquent so-and-so. Now she wants to live with her husband, but she claimed the husband so-and-so to give a plot of land to her, a pakka house in her name to live. She also claimed to give a so-and-so only as maintenance in the month of every month from her husband. Besides this, she also claimed to keep her and her son in the name, son's name in the service sheet of her husband so-and-so. In pursuance of her claim, delinquent so-and-so is willing to fulfill her demands, but delinquent is so-and-so is want to record the name of second wife so-and-so in his service sheet. Under the above facts and circumstances, it is found that delinquent so-and-so of this unit did not marry second time with so-and-so deliberately for his conjugal life, but he was compelled to marry for second time with so-and-so when his first wife, namely so-and-so, did not cooperate with the delinquent. It appears from the statement of witnesses and other relevant sources that delinquent so-and-so had tried his level best to keep his first wife with him, but she was adamant not to live with her husband without fulfilling the following terms and conditions. Conclusion also same, my lord, but as the permission has not been taken, my lord, this is the only dead ground, my lord, he was found guilty. Conclusion, she admitted she is receiving 7,500 as maintenance.
Where is the inquiry report? See.
Inquiry report, my lord. Page, start from page 20. Findings page 31. Statement and findings 32.
Where are the statement of allegation again?
Page 24. my lord. 25. 24. Statement of allegation 25.
Yes, anything to submit?
And regarding measure punishment, my lord, measure punishment including compulsory. Measure punishment, my lord, as per my lord, rule 7, my lord, 4 to 7.
Rule 7 of
The Assam Services Disciplinary Appeal Rules, my lord. Measure punishment, my lord, 7, then Roman 4 to Roman 7.
what is wrong in dismissal?
This is my lord, disproportionate, my lord, because this is very harsh, my lord, considering the.
You have compelled the authorities.
Not.
Why have you
And-
violated the conduct
And
rules?
the notice has been issued, my lord, in 2023, my lord. And it was given effect from that date, my lord. And the impugn order has been passed on the basis of the notification.
But even
Lordship.
then also, Lordship, he
It-
could have, that's my submission, Lordship.
In the impugn order, my lord, the
He could have.
Regarding his second marriage, Lordship, he could have informed the authorities, Lordship. When the office memorandum was published. Because these are binding upon all the government servant, Lordship.
So what is the position under the conduct rules?
This is an
It is already there in Rule 24 of conduct rule.
Yes, Lordship, 20.
but the definition, my lord, in this conduct rule, my lord, the civil services, my lord.
You are working under?
As a constable, my lord.
This civil service doesn't mean that, Lordship.
Definition 2B, my lord, government servant means any person appointed by government in any civil service.
Then what is civil service? This also has to be looked into, Lordship.
Third counsel for party.
May submit the Bombay High Court Division Bench judgment. Same point, my lord.
And the civil service implies to each and every government servant, Lordship. This is not upon particular category.
Civil service means civil service.
Lordship.
He's under the police.
Lordship.
So you tell us if there is anything under the Police Act.
Okay.
Lordship. Lordship, concluding hearing or
Yes, but if you have any judgment, you can pass.
Lordship, I shall.
Yes.
My lord, it's matter, pleadings are already changed, but what happened, my lord, senior counsel is the ARPI is on lag. So my lord may fix the matter after vacations, my lord.
Counsel for the petitioner submits the matter. Meetings are exchanged, matter be posted after vacations. Just in the month of August.
I don't, that would be little difficult to.
Right? What is the issue here?
Issue is, I mean, the petitioner has been deprived from the appointment of a post under junior engineer. My lord, despite he qualified and despite he cleared the cut-off marks, and he belongs from AWS category, his certificate was rejected. So my lord may take up the matter in the month of July, my lord.
Result
After
of
2 weeks of July are
two, Lordship.
on vacation, huh?
Result is of year 22, Lordship. They have
Let it
approached
be,
25.
let it be in August first week.
Lordship, by this time, what would happen? You know? I mean, the government has taken steps to, I mean, fill up all the vacant
When
posts.
do you want it?
Lordship in the after, immediately after resumptions, because I mean, matter was actually some urgency.
It is
pressing
fixed
urgency.
today.
Yes, Lordship, it is taken
You got it by order,
by order, my lord.
and then you are praying for an adjournment.
No, actually, Mr. Bia is on lag, my lord.
So are we to adjust the calendar as per the council?
No, Lordship.
Then?
Lordship.
Therefore, we are giving you a date,
Apologies.
giving you sufficient liberty to refix the date.
Yes,
Fix it in August.
my lord, any date in the month of June.
Any date is not possible like that, Mr. Council.
I mean, then put it after vacations, my lord.
Yes, we are putting it after vacation in the month of August. Make a mention. Ms. P. Sharma and for APSC, Mr. for. You're there. For respondent 1 and 2, Mr. D. Sikhi for respondent 6 and Mr. NZ.
N.A. Mazharvi.
Huh?
N.A. Mazharvi.
N.A. Mazharvi for the petition.
Lordship, the month of July last week.
We can't fix the date like that because once we fix a date, you are not available. What is the point? seeking an
My
adjournment.
apologies for that.
So you
Yes.
mentioned in the month of August, we'll fix a date.
I mean, I will mention in the month of July, my lord. Let it come in the month of July. These observations of month of August.
Pleadings are exchanged.
Yes, lord.
All right, then list it for hearing
Lordship.
in the month of August. Part 2. You
Lordship,
make a mention.
it will be too harsh.
No, nothing harsh. What is harsh?
Lordship, I mean, if the posts are being filled up, my lord.
If it is
Then-
filled up, then
then-
what can be done? Pass orders.
Any day, lord.
Your senior counsel is behind you, looking for you.
Okay. My lord, this.
August. That's what we said, August.
Can it be the last part of?
No, we have already explained. Let it be in August.
Month.
Yes.
Right.
Lordship, my senior counsel is on legs on court in court one Lordship. Kindly pass.
On the last date, you said medical emergency.
He is in one.
Huh?
He is on legs in court.
That's not a ground for adjournment.
No, we are asking for a passing.
We are not giving you a passover. Why should we give you a passover? Just for the asking. You get instructions if you have. Yes.
My lord, here, my lord, the petition had appeared for technician CSS and technician for assistant CSS, my lord, for both the posts as in terms of the advertisement, my lord. And after appearing in the written examination, my lord, he passed the written examination. Kindly turn to page 29, annexure E. This is the result of the written examination. This is for information of all concerned that the candidates who appear in the written examination for the grade 3 technical post under the Directorate of Medical Education.
Where is the selection order of
My lord,
showing you that you are selected?
my lord, this is in their affidavit at page 57, my lord. Page 58.
Show us the advertisement first.
Advertisement.
Page 21.
Advertisement 21 to 27.
Which post you are appearing?
For technical, for technician, for CSS and technician for assistant CSS. For both the posts.
Technician
for CSS.
for CSS, serial
Yes.
number 48.
Yes, my lord. And technician for assistant CSS. For both the posts, my lord.
48 and 50.
Yes, my lord.
Yes.
So after appearing the examination, he passed the, my lord. As per this result of the written examination, page 29, annexure in, my lord. This is the result of written examination. Here the petitioner's name, roll number appeared at page 30. My lord, at tick mark, my lord, technician for CSS and also for technician for assistant CSS, the next page, my lord, 31. So after that, my lord, as per this result, my lord, they were all the selected, all the candidates who have passed the written examination were asked to, my lord, appear before the Directorate of Medical Education for skill test and document verification. Accordingly, the petitioner also appeared, and after that, my lord, a select list was prepared, but petitioners were not selected, but their names appeared in the list, my lord. That list I have not annexed, but it is annexed in their, my lord, affidavit at page 58, my lord. In the status of, it is shown that the petitioner is eligible, my lord. And posts are also vacant, my lord, available. Page 58, my lord. Petitioner's name appeared at serial number 30, my lord. Serial number 30, and the status is showing as eligible, my lord. In spite of that, my lord, the petitioner has not been appointed, my lord. And in their affidavit, they said that since the petitioner has secured 38 marks in the written examination, affidavit, my lord, of the respondents, my lord, at page 54, my lord, para 4. the relevant portion I am reading, my lord, that he was found eligible for the post of technician for CSS, technician assistant CSS. However, the cutoff mark in respect of the aforesaid two posts was 67 marks unreserved categories, and the petitioner herein obtained 38 marks only on in his written test. As such, on that account, the petitioner was not appointed for the aforesaid two posts. Here, my lord, they were totally silent about the skill test, my lord, and my lord, in fact, here they are saying that in the written test he was not successful, whereas as per the result sheet notification, the petitioner has succeeded in the written examination, my lord. So this is contrary to their own notification, my lord, at page 29. And in the final result sheet also it is shown that the petitioner is eligible. Otherwise, my lord, those who are not eligible, my lord, it is reflected in the status as not eligible, my lord. Regarding the vacancies also, my lord, page 26, 55 numbers of vacancies as technician assistant for CSS and 48 for a technician CSS, my lord. And for general categories, 27 posts are available, and here 50 CSS for out of 48, 25 for general, my lord. The petitioner belongs to general category. In fact, the appointments are being made as per their choice, my lord. As per choice of the authority. And they cannot deny their own notification, my lord.
What notification?
Notification, that is the result of the written examination. It's clearly stated the petitioner has passed the written examination. He secured the required marks, my lord, page 29. This is for information of all concerned that the candidates who appear in the written examination for grade 3 technician posts and so, and at bottom I'm reading, under the following roll numbers have been shortlisted on the basis of marks secured in the written examination, and they are hereby directed to appear for skill test and document verification at Directorate of Medical Education. So since they are successful in the written examination, they were called for skill test and document verification.
I heard S.B. Chaudhary, counsel of the petitioner. Yes. Your name?
R. Sharma on behalf of
R. Sharma on behalf of
you command
the Permanent Council for the
health.
Health Department. The petitioner before this court. Anyone for the state? MSDT person appears for
Number 1.
respondent number 1. Petitioner submitted his candidature for the post of technician
For CSS.
technician assistant for CSS and technician for CSS, which is listed at serial number 48 and 50 in terms of the advertisement dated 6/11/2024. Stop. The eligibility criteria and other details are specifically mentioned in respect. Eligibility criteria vis-a-vis the posts are also mentioned in the said advertisement. For the said posts of technician assistant for CSS and technician for CSS, the qualification is HSS LC or equivalent with certificate course in CSS from government recognized institute. Stop. The category, the total number of vacancies reflected for these two posts are 55 and 48 respectively, with 27 posts for and 25 posts respectively in the category of unreserved candidates for the posts of technician assistant for CSS and technician for CSS. Pursuant to the selection process conducted, the petitioner claims to have been selected. However, claims to have been selected as his name is reflected in the result sheet to be shown to be eligible. However, no order has been passed as of date, permitting him to join. Stop. Pursuant to issuance of notice, the respondents have filed, Director of Medical Education has filed an affidavit where at para 3, the following averment was made. Para 4, extract. The said affidavit also contained the mark sheets for the post of technician assistant for CSS and the post of technician assistant, technician for CSS. Para. Name of the petitioner appears at serial number 30. It is shown to be in the category of general within quotes. He had secured written examination. He has secured 38 marks. He had secured 38 out of 100 in the written examination and 16 out of 20 for the skill test, and a total marks of 54 out of 125. So his status is shown to be eligible. However, the averment made in the affidavit, however, as per the averment in the affidavit, the cutoff mark in respect of the two categories of posts, two posts, namely, for the said two posts, namely the technician assistant for CSS and technician for CSS. The is 67 marks for unreserved category, whereas the petitioner obtained 38 marks only in the written test. Stop. Where a learned counsel for the petitioner submits that the result sheet which is enclosed to the affidavit contains the names of all candidates who are either shown to be eligible or not eligible. So, insofar as the writ petitioner is concerned, the petitioner is shown to be eligible. Petitioner's status is shown to be eligible. Whereas the same list also contains names of several other candidates who are shown to be not eligible. So, this position is not explained in the affidavit by the respondent. Stop. There is also no explanation as to the manner in which the cutoff mark was fixed. And the decision thereto taken at the appropriate level. And whether such a decision was taken prior to the conduct of the examination or post the examination undertaken. Stop. Under such circumstances, we permit the state to file a detailed affidavit explaining the mechanism, explaining the procedure for undertaking the selection for the posts, more particularly the post of so and so, in deference to in pursuance to the advertisement dated so and so. The affidavit must also explain why the name of the writ petitioner, as reflected in the result sheet, whose status is shown to be eligible, is not considered eligible as per the amendments made in para 4. So, let this affidavit be filed within 2 weeks. Stop. Matter be listed immediately after the reopening, by which date the affidavit is directed should be filed. It is made clear that if the affidavit is not filed as directed, court will proceed to pass orders on the basis of the pleadings available on record. Relist accordingly. Let that affidavit come.
My lord, this same, my lord, here
Similar
the
one.
petitioner's name appeared in serial number 31.
Same post.
Same.
He applied for both the posts.
Yes.
Here also affidavit filed.
Yes.
Same affidavit.
Wait, is it?
Yes.
Before I go to item number 43 is a motion note. And the rest are admission matters.
What are you challenging in 43?
43, I'm challenging an order of suspension at page 130. In this case, the lady is not against the party because it is purely between the government and I. The allegation is I have not completely obeyed the orders of transfer. I have not moved to Golaghat. And my stand consistently have been, I am having heart health, so these things followed. But before I take page 130, may I just indicate one thing? Because the first inquiry by the ICC was in my favor. Then they went for de novo. The de novo we challenged in item number 42. And the report of the de novo, my lord finds at page 132, which is again in my favor, in her presence. Page 132 for a moment. The operative part, my lord finds at page 153.
153
is the operative part of the de novo report. De novo we challenged at item number 42.
42.
In item, no, Lordship may have it. In this case only, page 153, Lordship may take the de novo report. It starts, at 132.
No, you're referring to which writ petition?
43.
43.
43, the motion.
43 is the motion.
Motion. I was giving a brief recap,
Yes.
The second de novo is in my favor at page 153. Starts at 132, operative part 153. Where is the operative part, the conclusion? After careful consideration of the complaint, written submissions of both the parties, oral depositions of the witnesses, documentary records, and electronic communications placed before it, the committee arrives at the following conclusion. The committee finds that while the complainant's grievances were communicated to the colleagues and superior officers, and certain circumstances lend partial support to her version, the available evidence is insufficient to conclusively establish all allegations on the standard of preponderance of probabilities required under the Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act 2013. Accordingly, the committee concludes that allegations of sexual harassment would not be fully substantiated on the basis of the evidence available on record. The committee further records that no finding of mala fide intent or false complaint is made against the complainant, as the evidence of pre-complaint disclosures to the multiple independent persons precludes any such conclusion. The inquiry is therefore concluded, and this report is submitted to the employer under Section 13 of the Act for consideration and such further action as the employer may deem appropriate in accordance with law. Pausing for a moment. This would have an impact on the two writ petitions at item number 42 and 40. Item number 40 was the challenge to the transfer. The transfer was for the reason that de novo would come against me. This lordship would find this order at page 97. We have annexed it here, 97.
Yes.
I invite my lord's attention to page 98, the penultimate part. The reason for the transfer. May I read?
Yes.
After balancing relevant considerations, it is found that posting Shahabuddin Chaudhary in the same district or in the neighboring districts may not be conclusive to ensuring a fair and independent inquiry process. The proximity of neighboring districts would enable frequent interaction with the complainant and potential witnesses, thereby creating a reasonable apprehension of influence. The transfer to a distant district serves the legitimate administrative purpose of maintaining neutrality and protecting the integrity of the inquiry process. The transfer order, right so-and-so, is not punitive in nature, but is an administrative measure taken in the interest of fairness and institutional discipline. This was for the reason that de novo inquiry was directed at page 87. Because of the de novo inquiry, if I do not move to Golaghat, then I will do A, B, C, D, E with the complainant and the witnesses. That was the pretext and the backdrop under which it was considered, and I was this was ordered that you move on to Golaghat. Now, if I invite my lord's attention to page 87, the second observation, whereas the government in the health and family welfare department, in view of the above, towards in view of the above, it is hereby decided as follows. 1. The inquiry proceedings of the Internal Complaints Committee culminating in the report dated 18/3/2025 was procedurally incorrect and not conducted in compliance with the provisions of the Sexual Harassment of Women at Workplace Prevention, Prohibition and
This is
Redressal
the
Act.
first inquiry.
No, this was the direction for the de novo.
This is pursuant to the first inquiry.
Yes, they said in substance, first inquiry is bad, go for de novo.
Right.
I challenged it in WPC 2046 at 42. Now de novo is held as lordship. I just led my lordship's attention to that. De novo phase, again, it says that no, nothing is there on record, and it was participated by the lady also. In this context, the transfer order.
Where is the de novo again?
The second de novo order. Lordship finds it at page 130.
Where are the conclusions?
Conclusions, my lord, finds at 153. So, the de novo which we had challenged would come to a logical end by the order. The conclusion at 153. So, the challenge may be good or bad, but the conclusion is in my favor. Number 1. The issuance of the direction for de novo was the reason from which it sprung up the reason for the transfer. Now, de novo is over. I am to retire in November. They are insisting to go to Golaghat. In these circumstances, perhaps transfer would not be warranted as of date. However, the writ petition which is for motion is on the premise that I had not complied with the orders of transfer, citing health grounds. They had asked for medical board. I had sought for time, but I could not appear on time. Therefore, I should be suspended, placed under suspension. In the fitness of things, they left out one thing. The order of suspension, which is under challenge, is at page 130. This would have nothing to do with the rest of the cases, but it would have a tangential bearing on their approach. 130. I would not trouble your lordship by the entire thing. If my lord would have the third last paragraph, Whereas Shahabuddin Chaudhary, senior assistant, failed to appear. May I read that part? Whereas Shahabuddin Chaudhary, senior assistant, failed to appear before the medical committee on the designated date 26/5/2026. The date is important. 26/5/26, as reported by the Principal cum Chief Superintendent GMCH, Gauhati by so-and-so 27/5/26. Next paragraph is, and whereas upon his request, a second opportunity was afforded to him by letter so-and-so, that is 26/5/2026 to appear before the medical board on 2/6/2026. And whereas Saab again failed to appear before the medical board by letter dated 3/6/2006, despite being afforded repeated opportunities. They left one document at page 122 that they ought to have considered and then placed me under suspension. Page 122 for a moment, that's a document from me, a communication from me, a request from me on 25th of May 2026.
So in this petition, what are you challenging now?
I'm order of suspension.
Suspension.
At this stage, it not call for me.
Right, so we'll issue notice here. What else do you want?
I'm praying that, since all inquiries can come to my favor, only on heart ailment I have proceeded. They did not suspend. I'm retiring in the month of November. Whatever they have tried, I have completely agreed to that. I have been in
They would be entitled to a notice.
He certainly. In the meantime, at the fag end of life of my service
In the
life,
meantime, what interim orders you want?
that suspension may not be.
That will amount to a final order. That's what you're challenging in the writ petition.
Subject to outcome. Subject to outcome. At least all proceedings I have endured with dignity. There's nothing against me as on date.
But
only on heart ailments.
Where is the order of suspension?
At page 130.
130.
They say I have not communicated. Page 122, I have communicated. They have not taken it on record. At least that should have been a part of record. I put the question to myself.
That was on 5/6. When did you receive it?
My lordship. Later. 22/5/2026. 22nd of May 26. I submitted my response.
No. Order of suspension, when did you receive it?
Sometime after 5/6. I cannot really have the instruction on the date.
That's okay. What we want to say is that at this
subject
stage
to outcome.
today,
Subject to outcome. That would say
subject to outcome what?
So this order of suspension, so far as this, I would really understand if they just stay on that, then what happens automatically, it might have a bearing one way of thinking that it's allowed because I'll proceed for retirement. But if
when are you retiring?
November.
November.
Therefore,
Enough time.
But a man who goes scot-free in all the proceedings.
We'll examine. We're not closing it. We're only saying that this is a writ petition where you are praying for setting aside of the suspension.
Now, if Lordship would take up,
respondents are entitled to a notice.
Then, so far as item number 40 is concerned, the transfer order.
First, let us deal with this. 3226. That's the petition from
my lordship.
Third come Mr. S. Banik, Senior Counsel, assisted by so-and-so. Mr. D.P. Bora, State Standing Counsel for Health Department. You're not here.
My lord, though the entire allegation.
You're
in other
you're
matters.
waiting to enter appearances, but you're not appearing as a party.
That's okay.
Third, Learned Counsel for the issue notice 4 weeks. The petitioner is putting to challenge the order of suspension dated so-and-so and actual so-and-so. Respondent may complete their instructions and file necessary affidavit, if so advised in the meantime. Mr. Bora and the other ends on instructions submits that the department proceedings have already been initiated against the writ petitioner by the communication dated 19/6/2026. Matter will be listed after the return of the report. Yes.
So far as item number 40 is concerned, that would be a transfer matter. Now the de novo is over in my favor. They do not require to transfer me out for 3 months. The requirement for transfer was on the ground that de novo is there.
But you are under suspension now. What difference would it make? Even if you set aside, unless the transfer order is suspension order is interfered with.
Fair enough. So what I'm praying with, on the merits of the matter, the transfer order does not stand on its legs for the reason it stemmed out of a requirement of de novo.
That's right, but to decide the transfer order effectively, you'll not get any relief unless the suspension order is.
Lordship may be kind enough to observe that under suspension I did not carry out the transfer. That's
you
all.
need not. No observation is required. You are suspended.
No, on the other hand, the proceeding on the suspension, the DP is initiated because of non-compliance.
Whatever it may be, but you did not comply with the transfer order for good
Genuine
reasons,
reasons,
bad
maybe.
reasons,
Whatever
whatever
it is,
reasons it may be. But now you are suspended.
Well,
Now there is no scope to carry
there's no scope for transfer, but
transfer.
the order of transfer would not be effective otherwise. Also on merits, what I'm saying, not
That
for the
will
case.
examine on the returnable date along with this.
And the de novo part, that matter.
What is this de novo 40?
De novo is 42.
42.
42. I challenge the de novo is not permissible. Now, since that I've been given a clean sheet in presence of the lady, nothing remains.
It is submitted. This is item number
42.
42 would be WPC 2046. This writ petition, the petitioner is saying the dispute order dated so and so, initiating de novo proceedings, de novo inquiry by the ICC.
Madam.
Pursuant to the allegations made by the private respondent is there?
Yes.
The private respondent. During the currency of the writ petition, the de novo proceedings were conducted and concluded, and the petitioner and no finding detrimental to the petitioner was arrived at by the ICC. So in that view of the matter, the writ petition has become infructuous, accordingly stands dismissed, has not pressed. Interim orders, if any, stands vacated, pending IS are also dismissed.
Only what I'm praying, in the transfer matter, so far as item number 40 is concerned, I squarely understand and I'm trying to persuade that the fallout of the suspension would be not non-requirement of interference in the transfer as on date, per se. On the prima facie view, but on the merits, a different issue. So that really can be indicated as under suspension. If my lord is not proceeding to for the present.
My lord, my small submission regarding the ICC's de novo report, my lord, I am not in agreement with my learned senior friend, my lord. Actually, the preponderance of probabilities principle has been followed, my lord.
He has challenged the proceedings initiation of proceedings. Proceedings has come to an end. That proceeding is not under challenge in the writ petition. Therefore, it is closed. We are not
no, my lord, I am with the observation that his submission has been recorded.
That is his submission. It is submission, not our finding.
So that one liner from your lordship, my lord, would have a bearing.
What one?
The transfer matter is not being taken up in view of the order of suspension holding the field as on date.
What difference does it
make? It makes a humongous difference, my lord. That observation.
Since the suspension of the writ petition and challenge in WPC 2045.
My lordships.
The challenge made to the transfer order in WPC 3266.
No, transfer order is 2045. Suspension is 3226.
Suspension is challenged in 3226 of 26. Is operating before the court. Court is insisting of the matter. Consequently, the challenge made into the transfer order in WPC 2045 is also directed to be listed together along with the same writ petition of the next returnable date.
I'm grateful.
Obliged.
The interim orders they may come. But there is an interim order at 41.
Yes, item number 7.
Interim order in 641. Let me continue.
Interim order in
item 41.
What is 41?
41 is a challenge independently. They have also proceeded on the same ground of sexual harassment and DP, which is not permissible in law. My lord, please to state for the moment.
Right. This item so and so will continue. Interim order. Yes.
Maybe Manodev Harding, Mr. Bideka is on Gunsmith. They have some difficulties also.
Yes, Your Honor, that the council is still stuck in a hospital, though matter may be listed after decision.
On joint request, the matter stands deferred to be listed again. Vacation.
And may I pray for a date? 28th of July, we have consent.
28th of July. Yes.
I will adjourn this matter to next day.
Counsel for the petitioner, praise for and its content. 6 an adjournment in the matter. This again after vacation. After the ensuing vacation, and so also appears for Mr. S.S. Roy.
This is right. Obliged.
May I please? See, take of the case is that petitioner, number one, is the legal wife of the deceased, and she has married with the deceased person on 3/4/2023 by customary rites. After her marriage on 26 January 24, their one son was born. And his birth certificate also I have annexed, my lord. The petitioner tried to state that before their marriage, this is Saidur Rahman opened a bank account at Mongoldoy State Bank of India, Mongoldoy branch, and which was issued in his salary account. At the time of opening he put his father's name, that is Muhammad San Muhammad, as his nominee. And similarly, after joining the service, he has opened a group insurance along with the other colleagues through State Bank of India of the Oriental Insurance Company by policy number so and so dated so and so. The copy of the said bank passbook and group insurance is annexer 7, look, page 23. This is the salary. That is the salary package account policy. My lord, he was a full government employee. From his salary, some amount was deducted for insurance, and government made a MU with State Bank, and State Bank done the insurance along with the Oriental insurance. So that is the case now.
What is the insurance? It's not a life insurance.
Life insurance, my lord.
Life insurance.
Yes, my lord. Policy package, life insurance, my lord.
This is a PSP account, my lord, for clarification. What happened in this case? There is a MU, my lord, signed between the State Bank and the police authorities, my lord, in 2024. Regarding if somebody is, my lord, during service period, any constable, police constable died, my lord, in maybe accident or one, they will entitle, my lord, 75 lakhs, my lord. That amount will be paid by the Oriental Insurance, my lord. Here is a case that petitioner husband was died, my lord, in a road accident in nearby Hatta, my lord. Then what happened? She submit, my lord. But in the original bank accounts, the nominee was found, my lord. That dead person's husband was father was the nominee, my lord.
In the bank account.
In the bank account. So according to the policy, isn't a nominee is entitled. Now question is, my lord, there is so many claimant, my lord. That petitioner is a, my lord, wife, and his minor sons was claiming that benefit, and also, and the father and mother of the deceased persons and brother also claiming that same benefits, my lord. We forwarded that proposal to the bank Oriental Insurance, my lord. Now, my lord, that Oriental Insurance, that our service provider, that original brokers, my lord, sought that regarding that mutual this one nomination clarification, my lord. That is the case, my lord. We have nothing else in that MU, my lord. Kindly look into that 11, my lord. My part, my lord. I have managed that, my lord. That
My lord, the point involved is very short. Your lordship come to page 22. The account of State Bank of India, your lordship will find nominee is Chan Mahmood.
This father, my lord.
Now, your lordship, Your Lordship, kindly see at page 24, the clause of the policy, clause 19, Your Lordship. The beneficiary on death of primary salary account holder shall be as follows. In case of account opened in single name, the nominee registered in salary package account of deceased will be beneficiary for the purpose of insurance claim. Bank's role will be limited only to certify the names of nominee as per bank records. So therefore, so far we are concerned, we shall pay only to the nominee, not any other persons. This is the case all about.
So what is the problem with the nominee? They are not willing to share.
No, that time, my lord, a nominee was in the State Bank, not transferred, because he was newly married.
No, nominee is the father-in-law.
Yes, my lord.
So is there a problem with the
Yes, my lord, he has now demanded he is the absolutely collect all this amount. We are not tenable this amount at all. Dear affidavit, my lord, page 87.
You are appearing for the father. Why don't you share it with your daughter-in-law and son?
No, I am not agree to 50 to 50. I am saying that as per personal law of the Muslim law, what share they will get, I am ready to give them.
What is the share entitled?
According to Muslim law, my lord, father and mother will get 1/6, and the wife will get 1/8, and the remaining part will be get the son, my lord. So that is the law. As per law, I am ready to get them. They are demanding the 50%.
You sort it out amongst yourself. Why? What orders do you want from the court?
My lord, they are denied to give me a single penny. That's why I am coming here.
True.
They are demanding and already bank and insurance also stated that the nominee will be get only the claim.
See, the money that you are claiming is a money given by the Oriental Insurance to the bank.
Yes.
As per the contract, it shall go to the nominee.
Yes, ma'am.
Nominee is your father-in-law.
Yes.
So, in the scope of that contract which was entered into, you were not a party. There was no agreement that portion of the amount will be shared with you or granted to you.
Oh, my lord, as per
Now,
Succession Act.
your claim in terms of Succession Act read with the Mohammedan-law is a claim that is open to you against the father-in-law. You go and urge that claim. That is a matter that has to be.
Now, question come, my lord, they are already paid them, and insurance and bank also ready to pay them. If it is paid, then their son and wife will be deprived.
No.
And on the other hand, apex court judgment also I have given there. And apex court stated, my lord, nominee is not a.
Nominee is the only custodian, my lord. He cannot swallow the entire amount. It will be distributed.
So, last part of my judgment, my lord, already I have stated that it is very much clear, my lord.
Which part of the judgment?
Last part of the judgment, my lord. Page number 9 to 10, my lord.
Yes. Paragraph?
Last paragraph. From the page number 9, my lord, already I have done paging number there, my lord. Moreover, there is no one other strong circumstances in this case from that, my lord.
Which paragraph?
Paragraph. Page number 9, paragraph number last one. Starting from that, here, my lord.
All right.
Moreover, there is one of other strong circumstances.
Yes, okay. This is with regard to the correct position of law.
Yes, my lord.
How is it relevant here?
No, my lord, here very clearly stated, my lord, that the nomination effect under section 39 does not deprive their right in the amounting payable under a life insurance policy. In support of that, this matter was disposed of by your apex court, my lord. This is an observation of so many high court, my lord.
Can you read the last line?
In view of above consolation, the judgment.
No, before that. Last line before that.
The amount, however, can be claimed by the heir of the assured, the accordance with the law of succession giving them. Yes, my lord, that is, as per succession, they will get. I am also ready to get their share. I am not saying that they will not get. Father and mother will get their share.
You make a claim in terms of the succession law.
My lord, that is now government is involved here. I am the government employer.
What government is involved there?
Because government deduct the money from my salary and they contact with the state bank.
No.
And state bank make the insurance with the Oriental insurance.
So you are asking for a shortcut that is not possible.
Now if
you want a high court to bypass the normal procedure and grant you an order. That can't be done.
No, my lord, immediately when they are going to file a petition before the state bank.
You go and file before an appropriate court, stake your claim under the law of succession, read with the Mohammedan law.
Yes, my lord, that will be taking the time, my lord. Already, if the
whatever time it takes, it takes.
But without servicing the anticipation notice, I cannot party. Government may be a party.
Maybe a party you express.
So if the money is already released in favor of the.
That is what I am asking you. What orders you want from the court?
My lord, if I am going to civil court, then till that amount may not be released in favor of the nominee, my lord. I am ready to go. On the other hand, if they are ready to take their share, I am ready to give them.
This petition pertains
Your Lordship, can you see? I want to clarify the matter. Here, neither the government nor the bank is involved. Your Lordship may see the clause 14.
No, we have seen that. But
yes. The insurance company only paid to the nominee. That's the legal position. And the nominee is the custodian. He cannot take away all the amount. It will be distributed among the legal heirs according to their person. That is the legal position.
That is all right, but there has to be a finding. What is the percentage to be given to?
Yes. That will be according to the personal law.
So who is going to?
That of course, this honorable court will not go into.
That is what we are asking him.
That they should go to the civil court and exercise their idea.
You are asking the High Court to get into the shoes of a civil court and distribute who is getting how much money, what percentage.
No, my lord. When
the interim, the order that you are asking for is a blanket order. Unless they agree, don't release any money. What kind of an order is this?
No, my lord. Already they are ready to pay the amount to the nominee. If the amount already released in favor of the nominee, then the wife and son will be deprived. Because son is a minor son, my lord. Only 3 years. What will protect his life, my lord?
This is something that you will have to follow as per the procedure laid down. So you will have to follow the law of succession.
So my humble submission before you, my lord, kindly give some time, my lord, before 2 months, my lord, to be a party of the government, my lord, it will be required. So until to party of the government, my lord, the matter will be not decided.
Until?
To be a party of the government may be party, my.
You are essentially seeking a direction to the private respondent
Yes, madam.
in a writ jurisdiction.
No.
You are seeking a direction to respondent 8 and 9.
Yes, madam.
Your dispute is with regard to 8 and 9.
No, I am seeking the relief. My direction to the.
They are not required to be directed because they are bound by a contract. They are not doing anything contrary to the contract.
My lord,
Contract says that it should be given to the nominee. So they are giving it to the nominee. The nominee is respondent number 8.
my question
Your
is this, my
your
lord.
claim is that the nominee.
If the claim is released in favor of the nominee, my lord, then the petitioner will be deprived. The money will be misused by the.
We are not restraining you from taking recourse to proper forum. When did your husband expire?
My lord, 7/7/2024.
24.
My lord.
And for 2 years, what were you doing?
No, my lord, we have correspondence with this insurance and others, but they are refused to pay the amount to me.
Naturally, because that's what the contract says. You are not a party to the contract.
They are.
You did not execute the contract.
Yes,
you are
my
not
lord.
an employee of the state.
That time I am not there.
Then how are you claiming rights under the contract?
Because my husband was the insurer.
If you don't wish to understand, then we can close it right away. We are trying to make you understand that you have a remedy before an appropriate forum.
Yes,
you
my lord.
refuse to go there. You are insisting that an order be passed by the court
No, my
against
lord.
the private respondent.
No, my
You
lord.
can't do that.
No, my lord, I am not in this point, my lord. My humble submission before this court, if the amount released in favor of the private respondent.
Can there be a blanket order that this amount shall never be released until the writ petitioner goes to a civil court, gets an injunction, gets an order, gets a decree in his favor? Can it be done?
Then my lord, what will be the.
We don't know. You are the lawyer. You advise your client. What will be? Why are you asking the court about for your legal advice?
My lord,
the issue is very simple. Your dispute is with respondent number 8.
Yes.
You are roping in the government so that you can come to the court for filing a writ petition. We are not issuing orders. Your remedy is elsewhere. It is open for you to go.
My lord, kindly.
You have your answer to the problem, but you don't want to take recourse to that. Whatever reasons it may be, they are better known to you.
My lord, MO done by the government with the State Bank, my lord. And my amount was deducted, my husband's amount was deducted from the salary, my lord. And that amount they are insured.
Have you challenged the contract? Have you challenged the contract? That this is a void contract, voidable contract.
No, my lord, I am not going to challenge the contract, my lord.
Then? Heard learned counsel for the petition. We have given you enough time. You are refusing to understand the position in law. You are aware that the proper course of action is to go and approach it.
So, my lord, I am going to ready to go.
You go there. Who's stopping you?
Till date, my lord.
Till date. What is the meaning of till date? Give us a time for 1 month, 2 months, 3 months.
No, my lord. Immediately I am going to.
Then what is the protection you want?
I want to protection only for that they are not release the amount in favor of the.
For how long? For how long?
Till date, my lord. 1 month, my lord.
1 month. All right, 1 month.
Within the 15 days, I am filing this.
All right, till 1 month. Yes. Are you agreeable to share? Your daughter-in-law and your grandson.
Yes,
Ah.
already
He has a ground to disagree. He says, as per the personal law, the property has to be decided as per the personal law. Huh?
by the other expense after deducting that matter, then only this
Heard the counsel for the parties. Mr. You're Mr.
Yeah, maybe.
AR Medi appears for the writ petitioner, Mr.
K Das, your lordship,
Das
for
for
responding 4 and
SBI.
5.
Mr. Jiuddin for respondent number 8, MSDD Burman. 8 and 9, MSDD Burman for the 1, 2 and 3. Mr. S. Dotto, senior counsel.
6 and 7.
Has been requested by the court for his assistance in respect of the insurance companies, since none had represented the insurance company pursuant to notice being issued. The petitioner before this court, the widow of late Sadidur Rahman, who was employed under the Assam police. So during his tenure, the employer, namely the Assam police, entered into an MOU with the Oriental Insurance Company, and the effect for the benefit of, within quotes, personal accident insurance cover in respect of the employees whose names are included in the. There must be a schedule or something for all employees.
No, my lord, there is a MU in different departments, my lord. This is a MU signed between that, my lord, police department and that SBI.
That is what we are asking you, police department as a whole, or only in respect of the list?
Whole, my lord.
The insurance cover is in respect of all the employees of working under the police department. And in terms of the employees, in terms of the insurance cover, on the death of the primary salary account holder, namely the late husband of the writ petitioner, the beneficiary would be, in case of account opened in single name, the nominee registered in the salary package account of the deceased. Stop. So far as the writ petitioner's late husband is concerned, he had a bank account in the SBI opened in single name, and the nominee in the, so far as the account is concerned, is, as reflected from the records, is the respondent number 8, who is the father of the late employee, the deceased employee. So it is the submission of the counsel for the petitioner that after the demise of her late husband, she staked claims for the insurance benefits before the police department for her as beneficiaries of her late husband, on her own behalf and on behalf of her minor son. So the police department, however, declined to release the beneficiary, the beneficial amount, the insurance amount, as in terms of the policy. In terms of the conditions, terms and conditions of the policy, it is only the nominee registered in the salary package account of the deceased who will be treated to be the beneficiary for the purpose of the insurance claim. So, as the name of respondent number 8 is reflected in the bank account our late husband as the sole nominee, the claim of the writ petitioner was not entertained by the respondents. Being aggrieved, the present writ petition is filed. Thereafter, the respondent number 3 has contested the matter by filing the affidavit stated in para 7 of the affidavit that as per the service sheet, the deceased Sadidur Rahman entered the name of his mother, namely respondent number 9, as a nominee in the service sheet. However, after the death of the employee, his wife, namely the petitioner number 1, submitted an application along with the next of kin certificate to the office of the deceased, to the office of the respondent authority, requesting to enter her name along with her son's name in the service sheet. Stop. On such request, on the basis of the next of kin certificate, the name of the petitioner number 1 and her son were entered into the service sheet. As per the averments made in the affidavit, the payment of leave encashment / GIS savings and insurance total amounting to a total of rupees 5,23,430 has been drawn and deposited in the SBI account number so-and-so, page number 63, which is the account number of the writ petitioner, ID bill number so-and-so, dated 25/11/24, for an amount of rupees 3,04,545, and bill number 370, dated 25/11/24, for an amount of rupees 2 lakhs, and a bill number 371, dated 25/11/24, for an amount of rupees 18,885. Stop. SBI authorities have also contested the matter and filed their affidavit. Wherein at para 4, it is stated that in terms of the MOU entered with the Assam Police on 22nd of March 2024, all Assam Police personnel are eligible for personal accident insurance coverage of 75 lakhs, provided the said police personnel is having a salary account with SBI and the salary is being credited to SBI.
Yes, 10 is 64, my lord. Planning based method. Paragraph 5, my lord. The next page, my lord. MU, that is just 10 minutes.
stated that the claim for the insurance benefits has been submitted by the father of the deceased employee, namely respondent number 8, which however is pending for want of certain documents.
And kindly, my lord, paragraph 10 of MU, my lord, that portion.
It is stated that in terms of the MOU, the benefit, the insurance benefit means to be released only to the beneficiary, only to the nominee whose name is reflected in the as a nominee in the salary account held by the deceased employee. So, since the name of the father-in-law of the writ petitioner, namely respondent number 8, is shown to be a nominee in the salary account, the bank has to release the amount in favor of the nominee in terms of the MOU executed by and between the, this is SBI
My
and
lord,
the police.
My lord, what happened, my lord? Para 10 of the MU, my lord, is clear, my lord. That payment has to be made by the insurance company, that is Oriental Insurance Company. There's a 64, my lord, that para 10 I have put it here, my lord, the MU, my lord. All the correspondence relating to claim will then be directly taken up between the insurance company and the claimant without involving bank. All the settlement dispute will be between the claimant and the insurance company, and the bank will not be party of such dispute. Here, my lord, we are only an authority to forward the documents to the insurance authority. We are forwarded.
It is further submitted that in terms of the MOU is executed between
my lord, SBI and my lord, police personnel, my lord. The MU I have
in terms of the MOU.
Paragraph 10, my lord.
Clause 10 of the MOU. All the relevant correspondences, including the claims made on behalf of the deceased police personnel, will be forwarded to the insurance company, namely the Oriental Insurance Company, and thereafter the claim settlement will be entirely the responsibility of the insurance company, and the bank will have no liability towards any claim or disputes or continuation of insurance benefits in respect of the policy. So, you have forwarded the papers.
My lord, the status report have annexed here, my lord. And the next page 65 is clear, my lord.
It is submitted that all correspondences pertaining to the claims made on behalf of the deceased police employee and police personnel has been forwarded to the Oriental Insurance Company, and ultimately it is the insurance company who has to settle the claims.
Now, my lord, that status is showing that affidavit required regarding clarification of names of nominees. That's 10. Status report, so I have annexed here, my lord.
Page number?
My lord, in my affidavit 65, my lord. Capital letter, my lord, that the claim settlement was pending with the Oriental Insurance Company for want of some necessary document. Affidavit required regarding clarification of name of nominee.
Mr. S. Dr. Nanak, Senior Counsel, appearing for the Oriental Insurance Company, submits that the terms of the insurance company is very clear, and there is no dispute that the amount has to be released to the nominee of the deceased employee, and in terms of the records, and as per the records, the name of the nominee is the nominee of the deceased employee is the respondent number 8. Stop. He, however, submits that any claims with regard to any other stakeholders claim to be legal heirs will have to be paid as per the procedure prescribed under the law. So far as the contract agreement is concerned, / the MOU is concerned, it is the nominee who has to be, his name is reflected in the bank account, who has to be release the benefit. So, Mr. Jiuddin, appearing for respondent 8 and 9, also submits on the basis of the affidavit filed that insofar as the bank account is concerned, it is the name of the father who is shown to be the nominee, and his deceased employee's mother, namely respondent number 9, is a nominee in the salary account. It is submitted that from the records available, it is clear that the deceased employee, their deceased son, wanted to keep the parents as a nominee, notwithstanding that he was married at the time when he had entered these particulars before the employer. So, it is submitted that since there is already a nominee specified, there is no question of the writ petitioner claiming the amount has to be released to the nominee specified. Mr. Jiuddin, however, on instruction submits that he is willing to share the amount with the writ petitioner. 50% of the amount, subject to such concurrence by the petitioner. Well, the learned counsel for the petitioner submits, places reliance on the judgment of the apex court rendered in Srimati Sarbati Devi and other versus so and so, reported in 1984 1 SCC, page 424. In terms of the judgment, the learned counsel for the petitioner submits that mere nomination will not have the effect of conferring the nominee any beneficial interest of the amount payable under the life insurance policy on the death of the assured. The nominee only indicates the hand which is authorized to receive the amount. The amount, however, can be claimed by the heirs of the assured in accordance with the law of succession governing them. So, it is submitted that as per Muslim personal law, the petitioner, being the widow of the government employee, is entitled to 1/8.
Yes, ma'am.
1/8 of the total share, and the parents of the deceased employee, namely respondent 8 and 9, are entitled to 1/3.
1/6.
1/6 each. Stop. He therefore submits that the writ petitioner's claims. He therefore submits that if the respondents 8 and 9 agree, share the amount of insurance benefits in the ratio as prescribed under the Mohammedan law.
The remaining part will be get the son minor.
And he has no difficulty in accepting same. What is the wife's share?
Wife's share 1/8 minor.
1/8.
Father and mother 1/6.
And son?
Son a remaining portion.
Okay. Wife 1/8, father, mother 1/6 each, and the remaining portion be given to the son. Para considering the submissions made and taking into consideration the pleadings available, and also the judgment rendered by the apex court, appears to court that the dispute between the petitioner and the respondent 8 and 9 is in effect with regard to the claims of the insurance policy. So the deceased employee as also the petitioner and the respondents number 8 and 9 belong to the Mohammedan community, and it is submitted that they are governed by the Muslim personal law, under which the claims of the widow would be 1/8, the claims of the parents would be 1/6 each, and the balance would be available for the son. So these claims, however, as on date, admittedly are not made by the petitioner before a competent court of jurisdiction, having jurisdiction to entertain claims under the succession law as also under the Muslim personal law. Stop. The apprehension expressed by the petitioner is the release of the entire amount in favor of the dead petitioner, pursuant to which the claims made by the petitioner may not be available to her. Stop. The agreement executed by and between the police department and the insurance and the SBI has been carefully perused. What is that, page 23? Page 23.
23, my lord. General guidelines, my lord.
This is appended to the policy.
Yes, my lord.
And where is the agreement? The MOU?
MU, my lord.
I appendix.
Is number 37, my lord. 38, 738. Memorandum of understanding, 38, my lord.
As per the MOU available in the affidavit filed by the SBI. All claims regarding the insurance policy are to be submitted directly to the insurance company, and the settlement and disputes between the claimants and the insurance company are to be settled by the insurance company. The bank is not to be made a party to such disputes. So the general conditions which are general guidelines which are appended to the policy reflects that the beneficiary on the death of a primary salary account holder to be the nominee whose name is entered into his name is reflected in the salary package account of the deceased. Stop. From the pleadings, essentially it is seen that the dispute is between the petitioner and the respondent regarding the share of the insurance package which was entered, which was subscribed to by the deceased employee in terms of the MOU. Stop. The claims made by the writ petitioner in terms of the law of succession and the Muslim personal law will have to be determined vis-a-vis the claims made. Will have to be determined vis-a-vis the counterclaims made by the respondent 8 and 9 by a competent court exercising jurisdiction over such matters. Considering that the matters will require deducing proper evidence, this is not a matter to be dealt with by writ court, as there will be there are likely to be disputed questions of facts, and the requirement of deducing proper evidence will have to be taken recourse to by the court before arriving at a conclusion regarding the intersect claims of the writ petitioner and the respondent number 8 and 9 in terms of the succession, law of succession and the policy. So, law of succession and the Muslim personal law. Stop. While it has to be accepted that the mere reflection of a name of a person as a nominee will not disentitle other claimants otherwise entitled under a personal law or in terms of the law of succession. The fact remains that the claim of the petitioners under the respective law vis-a-vis the claim of the respondent will have to be determined by a competent court. As on date, no such the petitioners have not taken recourse to such proceedings. So it is submitted by the counsel during the course of the hearing. It is submitted by the counsel to the petitioner that on instructions that they are taking steps to pursue their claims before a competent court in respect of the claims under the Mohammedan law, and stake their claims as per the law of succession. So, if that be so, then the claims of the writ petitioner vis-a-vis the claims of the private respondents will have to be left to be determined by a court of competent jurisdiction on the basis of such evidence as may be adduced before, and on the basis of procedure prescribed under the provisions of the law applicable. So, in such circumstances, this court refuses to exercise its jurisdiction, determine the rights of the writ petitioner in respect of the claims made without there being a proper materials before the court and without reducing proper evidence. Stop. However, the disposal of the writ petition will not act as a bar for the petitioners to approach a competent court and stake their claims in terms of the Mohammedan personal law and law of succession. Stop. It is submitted by the counsel to the petitioner that they would take immediate steps to pursue their claims before a competent court. Under such circumstances, since the amount of insurance claim has not yet been disbursed, the writ petition stands closed, directing the respondent authorities, more particularly the insurance, Oriental Insurance, as also the SBI authorities, not to disburse the insurance claims of the writ petitioner, of the late husband of the writ petitioner, namely the deceased employee, for a period of 30 days from the date of receipt of a certified copy of this order, or till such orders are passed by a competent court of civil jurisdiction. The petition disposed terms of the yes, there are judgment also. We'll dictate the order.
Miller.
Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. B. K. Das, counsel for the petition. And who's for the respondent, name is Didi Burma. Mr. R. or Dinath. In absentia.
He was here, no, my here, my lord, but he argued the matter, my lord. That is why, my lord.
Dinath. Hearing learned senior government advocate. Hearing for the respondents. Stop. The petitioner is a civil servant, is a civil service officer. He is presently still serving.
Yes.
Serving as a joint secretary to the government of Assam, textile and sericulture department. The basis of certain complaints received by the department, an inquiry was instituted into the anomalies of selection process relating to 6 master weavers under the Directorate of Handloom and Textiles Assam. Stop. Petitioner was appointed as the inquiry officer. Stop. He conducted the inquiry and submitted his report on 16/6/2022 to the senior most secretary to the government, the department. Stop. Subsequently, competent authority disagreed with the conclusions arrived at by the writ petitioner as an inquiry officer, and finding fault with the inquiry report, a departmental proceeding was initiated against the writ petitioner. So, petitioner was issued this. Where is that?
Yes.
This
Show cause notice, Miller.
so far as the petitioner is concerned.
Page 59.
Show cause notice dated 20th of March 2023. Whereby it's alleged that the petitioner had given a clean cheat to the recruitment process and which was misleading and factually incorrect. And pursuant to another report, it which reflected on a series of irregularities in the recruitment process. And based on the report of Deed and Secretary, Handloom, Textiles and Sericulture Department, the inquiry report submitted by the petitioner was found to be false, incorrect, and containing misleading facts. So, the show cause notice was accompanied by the statement of allegation and the list of documents and witnesses. So, and the petitioner thereafter was called upon to show cause, and he submitted his written reply dated 12/4/2023. So, the inquiry was conducted, and where is the inquiry report?
It starts at page 103, Miller. And the operative portion is at 105.
The inquiry officer concluded that the charges framed against the writ petitioner are found to be true. So, the inquiry report was submitted to the disciplinary authority. The disciplinary authority accepted findings of the inquiry report. A copy of the report and a notice was also issued to the writ petitioner requiring him to represent the conclusions arrived at by the in the inquiry report. Stop thereafter by order dated, impugned order dated 25 June 2024. The respondent authorities imposed a punishment or penalty of withholding one increment with cumulative effect upon the writ petitioner. And the disciplinary proceedings by the show cause notice dated 28/3/2023 was disposed of. Stop. The writ petitioner preferred an appeal under Rule 15 of the Assam Discipline and Appeal Rules, and which also came to be rejected.
No, Miller. Penalty was converted to censure. Page 126.
And the penalty was penalty, order of penalty was converted that of censure under Rule 7 within bracket 1 of the Assam Services Discipline and Appeal Rules 1964 by the order dated 4th of November 2024. So, being aggrieved, present writ petition is filed. So, the learned senior counsel submits that the charges leveled against the writ petitioner do not make out any misconduct which will entail a departmental proceedings to be initiated against the writ petitioner. So, it is further submitted that the charges leveled against the writ petitioner are vague and therefore it is not capable of being discerned to be any misconduct under the rules. Therefore, the conclusion of the inquiry officer holding that the charges to be proved, the consequential orders passed by the disciplinary authority as also by the appellate authority are totally unfounded and therefore required to be interfered with, set aside and quashed. In support of his contentions, the learned senior counsel relied upon the judgment of J. Ahmed, reported in 1979 to SCC 286, in support of his contentions as to the definition of misconduct. So, he further relies on the judgment of the apex court rendered in Girish Chandra Sharma, reported in 2007 7 SCC 206, submit that the courts are not required to sit over as appellate authorities. And
This was in the context of page 28, that inquiry report which is submitted, it was supposed to be vetted by senior most secretary. It was in that context, JC Sharma.
it is submitted that the inquiry report which was submitted by the writ petitioner was also vetted by the senior most secretary and defects were found. Therefore, it is improper for the department to initiate inquiry only against the writ petitioner and without any proceedings initiated against the senior most secretary and other senior officers who had did not find any fault with the inquiry report submitted by the writ petitioner. So,
Lordship's kind permission with another.
yes, yes. The respondents, the other end, contest the matter by filing an affidavit disputing the charges leveled against the writ petitioner. It is submitted that the inquiry report submitted by the writ petitioner did not give any specific observation as was expected out of him as to whether the selection procedure was as per the government approved procedure. It is contended that the report placing the facts were totally incorrect and had rather indirectly given a clean cheat to the recruitment process when the reports of the secretary revealed the process to be otherwise. It is contended that there were several irregularities in the recruitment process undertaken by the then director, Handloom and Textile, and it was not as per the government procedure. And there were irregularities in the process which the petitioner failed to reflect in his report, even though he's a senior officer of the department, and the allegations to which he was inquiring were of grave nature and moral turpitude. So, under such circumstances, it is stated that the department had correctly proceeded against the writ petitioner by issuing a show cause notice, to which the petitioner replied, and the inquiry concluded, holding that the charges to be. The departmental authority thereafter imposed the punishment, which subsequently came to be modified by the appellate authority. So, therefore, submitted that there's no anomaly in the process undertaken, and the scope of judicial review for interference of such proceedings is limited, and unless the petitioner, unless it is able to point out the glaring irregularities and the anomalies that may have been resorted to by the respondents in conducting the inquiry proceedings. Since no such shortcomings are seen from a bare perusal of the inquiry report and the subsequent orders passed by the departmental authority, no interference is called. Are there any judgments relied upon by the respondent? Learned counsel for the parties have been heard, pleadings available on record have been carefully perused. The show cause issued against the writ petitioner. Where is the show cause again? Page number?
'59.
59. Laid down the following allegations against the writ petitioner, page number 59, 1 and 2. Roman 1 and 2, 1, 2 and 3 as a interval. So, there are the statement of allegations against the writ petitioner, where R is under, means page number 61 to extract. The show cause notice was is enclosed by list of documents and list of witnesses. cause notice issued was replied to. And taking a stand that the report submitted by the writ petitioner as the inquiry officer was deficient or any negligence or fault would have been is attributable to the petition. What is this? Huh? Okay. So in order to address the question raised by the writ petitioner that the allegations made in the show cause notice are vague and do not construe any misconduct. It is necessary to refer to the show cause notice. So, their perusal of the show cause notice does not reflect that any specific provision of the rules or the memorandum or notification or any clauses of any contract or guideline has been referred to submit that the petitioner is guilty of petitioner has committed any misconduct. Stop. The specific allegation in the show cause notice is in respect of two instances where two of the selected candidates who were appointed in the office were subsequently appointed under the Department of Handloom and Textile were shown to have attained 10 years of experience, and they were both aged 20 and 18 years respectively on the date of the interview. Stop. The inference sought to be made by the department is that they, in order to accomplish 10 years of experience, they would be fairly underaged at the time of being employed, and which is a violation of the Child Labor Prohibition and Regulation Act 1986. Stop. From a perusal of the show cause notice along with the statement of allegation, it appears that it appears that the department had raised certain queries in respect of the selection process which was undertaken earlier, and for which the writ petitioner was entrusted with the responsibility as an inquiry officer and to submit his report. Stop. The report submitted by the petitioner, according to the respondent department, is deficient as it did not take into account several factual issues which were clearly evident upon perusal of the records relating to the recruitment process which the petitioner was required to make necessary inquiries. Stop. Well, the rules of 1964 does not clearly define misconduct. So the plain reading of the show cause notice along with the statement of allegations does not reveal that the petitioner, that the allegation against the petitioner is violation of any specific rules or regulations during the process of the inquiry undertaken by the petitioner, which he did not follow. It appears to the court that the only reason for proceeding against the petitioner is the report which was found to be deficient. So, any inquiry conducted by the department through an officer, if it is found to be deficient for some reason or the other, it is open to the department to undertake fresh inquiry. Stop. But whether an inquiry report which is found to be deficient and not as per the and found to have not taken into account certain facts, would it amount to misconduct? Is the question to be decided in the present proceedings. In the absence of any specific definition under the rules, the recourse will have to be taken to the judgments rendered by the apex court. In J. Ahmed Supra, the apex court had explained deficient misconduct. In the context of All India Services within bracket Conduct Rules 1954. So, the apex court held the lack of efficiency or failure to attain the highest standards of administrative ability while holding a high post would not themselves constitute a misconduct. It was further held that a single act of omission or error of judgment would ordinarily not constitute misconduct, though if such error or omission results in serious or atrocious consequences, the same may result in a misconduct. Stop. It was further held that any act which may not involve mens rea may still construe misconduct for disciplinary proceedings. However, mere error of judgment or inefficiency would not by itself be construed as misconduct. The relevant paragraphs of the judgment are extracted below. In 2002-3 SCC reported, Ramesh Chandra Manglik reported in 2002-3 SCC 443. The Court explained negligence in duty when can be construed to be a misconduct. It's held that negligence in duty may amount to misconduct in certain cases where consequences may be directly attributed to the negligence of the delinquent, resulting in heavy losses. The charges of misconduct will not result from mere omission or lack of competence by the delinquent officer. So, the relevant paragraph are extracted below. The further argument of the counsel for the petitioner that notwithstanding the approval of the inquiry report by a superior officer, notwithstanding the approval of the inquiry report submitted by the petitioner by a superior officer, the proceedings are drawn up only against the writ petitioner, whereas no proceedings are initiated against the superior officer. It amounts to an action of where the government has decided to pick and choose only the respondent authorities, only the delinquent officer. So no explanation is furnished by the respondents in their pleadings to suggest as to why only the writ petitioner has been singled out or being proceeded with without taking any initiative or without any explanation as to whether any steps have been taken to the higher officer who had approved the inquiry report submitted by the writ petitioner, which the department concluded was inaccurate, misleading and factually incorrect. Stop. The apex court in Girish Chandra Sharma had the occasion to deal with such a situation where the court held that collective decisions in which others had also collectively participated, the single person cannot be made responsible and made a scapegoat for the fault of others in a process where others had collectively participated. Stop. Another aspect of the matter, specifically here, is the allegations made in the show cause notice against the petitioner is required to be specific. So, unless the delinquent officer is made aware of the charges leveled against him in a manner so that he can respond. So, come on. The proceedings initiated against any such officer will be contrary to the specific provisions laid down in the disciplinary appeal rules. Stop. In the coming to the facts of the present proceedings, the ground which the charges are leveled against the writ petitioner that they are found to be misleading, factually incorrect, and not based on record. Without specifically pointing out to the in the charge sheet as to how this amounts to misconduct. So, at best, it can be said that the conclusions arrived at by the writ petitioner was due to error of judgment or lack of competence. But for the same to be misconduct, there must be specific and allegations so that the delinquent officer is able to defend his case by filing appropriate reply. So, we over the above discussions, the writ petition stands allowed. The impugned order passed by the disciplinary authority as also by the appellate authority stands quashed, set aside. The petitioner would be entitled to all service benefits which otherwise he may not have been entitled in view of the orders passed. Disposed.
Lordship,
Yes.
one more submission, Lordship. Actually, this IS nomination is pending, Your Lordship. Some observation.
That the department will take as and when it comes.
Actually, my juniors have been promoted, Lordship. The meantime,
This is not a claim here. Disposed. Pending IS are also dismissed, pending interim orders, if any, stand vacated.
there is a prayer, Your Lordship, for this service benefit of
The service benefits we have already directed, but your nomination for IAS is something that you'll have to claim separately if you want. Yes, disposed.
In this case, I would like to make a prayer that my petition perhaps will become infractor. So unless and until, my lord, I make some intimation to my client or without their, lord,
It has become infractions, we close it.
my lord, only problem is that, my lord, nowadays, Lordship knows, my lord, they may put a question that you did not intimate us. So, my lord, one more chance may be given to me.
This is for what? What are you praying
My
for?
lord, relates to my lord, there is a rule, and in terms of the rule, my lord, they are to hold a selection for, my lord, admission in Assam Service Settlement Training Center.
For which year are you claiming?
That was, my lord, perhaps, my lord, 2018 and 19.
Then what remains now?
That's why, my lord, I'm saying it is in infractions. And in the meantime, my lord, everything is over.
That rule has also such a repeal, Lordship. Now
Rule is also repealed.
The rule at that point of time, lord, there was no amendment.
Now new set of rules will come.
Yes, my lord. So, my lord, only, my lord, so let me intimate.
Mr. A.K. Pulkastal, learned counsel for the petition, submits that the writ petition submitted with fairness that the writ petition has become infractional. However, he be permitted to inform the writ petitioners. He be permitted with an opportunity to communicate the same to the writ petitioner. Thereafter, the matter can be closed by the court on the next date of listing. Mr. B.C. Zari appears for the PTC.
Respondent number 2, 3, 6 and 7.
3, 6 and 7, Mr. S. Doctor for Revenue, MSDD Bormon for State. Release this matter again on 24th of July.
I am abreast. 47.
Yes.
Matter relates to the petitioner's dismissal, Lordship. Annexure 4, page 42, is his dismissal order.
42.
42, Lordship, page 42. Forty-three is the operative part, Lordship. Upon consideration of all the materials in its entirety, including the show cause statement of witnesses, documentary evidence, reply to show cause notices, and report of the inquiry, I, as the disciplinary authority, seems it appropriate to impose penalty of dismissal of service to the petitioner on finding sufficient materials of his involvement in taking bribe and is ordered accordingly. This order was passed post his retirement. Thereafter, Lordship, we filed an appeal, Lordship, which is on Annexure 6, page 57.
Appeal rejected.
Yes, Lordship. Appeal rejected. No speaking order was provided, Lordship. Moreover, Lordship, in fact, this order also, page 43, Lordship, after retirement, Lordship, they could have only gone through Assam Service pension rules, Lordship. They have given punishment to me under Assam Service disciplinary rules. Post-retirement, this order is. I retired from service in the year 2019. And the dismissal order is in 2023 December.
The proceedings were initiated prior
before.
to your...
Yes, prior to before. Yes. But technically, Lordship, punishment should have been under Assam Service pension rules. Even if it's a deemed procedure. Lordship.
How can your pension is governed by the pension rules?
Yes, Lordship. Lordship, the statement of allegations, that is annexure 1, is on page 22. Lordship.
records and everything are available.
Records, Lordship, what is, they have provided me a record. I have gone through the same, but what I have found out, Lordship, that is not a record in connection with the DP. They have sent the CD, Lordship. Case diary has been sent. So, Lordship,
What is the ground for?
Ground is, Lordship, first of all, Lordship, in page number 29, Lordship, which is examination of witnesses, Lordship. This is from where the examination of witnesses start, Lordship. This is the trap-laying officer, Lordship, who is Suleiman Ali, Lordship. His statement
What is the
only
what
a
is
written
this?
statement.
What is the stage of the criminal proceedings?
Lordship, it's still not charge sheeted, Lordship, due to the want of prosecution sanction till now. He could not appear, so a written statement was sent. That is on page 30, exhibit Z11 is the written statement of witness Muhammad Suleiman Ali. This is the first thing, Lordship.
Page number
30, Lordship. Page number 30, first paragraph. Then after exhibit Z11, page 30, Lordship, Z11. This is the statement of the trap-laying officer, Lordship, not recorded. It is a written statement, Lordship. It was sent. So I did not get any opportunity to cross-examine also.
no, Suleiman Ali deposition is here, page number
Yes,
29.
declaration is there, but he sent his recorded statement, written statement, Lordship. It was not recorded.
Page 30 contains the examination of witnesses.
Yes, Lordship. Starts from page 29, Lordship, examination of witnesses. Page 30, Lordship, which is the trap-laying officer statement. At the end, Lordship, it's exhibit Z11 is the written statement of witness. Suleiman.
Recorded statement.
Yes, written statement. It is not a recorded statement, Lordship.
No, it is said recorded statement here.
No, Lordship, exhibit Z11. I'm talking about exhibit Z11. That is
Z11.
Z11.
Is the written statement.
Written statement. It is not recorded, Lordship. So I did not get an opportunity to cross-examine.
Who is Sulaiman Ali?
He is the trap-laying officer, Lordship. He is the TLO in this case, Lordship. He is the trap-laying officer in this case. Thereafter, Lordship, this is witness number 2. His statement has been recorded as exhibit Z18, that is on page 30. That is fine, Lordship. Thereafter, Lordship, his statement was recorded. He was also given an opportunity to cross-examine. Then thereafter, in 3, Lordship, it is the statement of the delinquent, Lordship. This is the petitioner, Lordship. The petitioner, that after going through the statement witness, the delinquent has raised objections to the alleged receipt of an amount of rupees 6,000 as bribe. The delinquent has started that the complainant Ansar Ali came to Korbaha PP along with the bail order obtained from court. After going through the bail order, the delinquent had given bail and released him. In the meantime, the complainant Ansar Ali tried to give him some cash amount. The delinquent has started that he had not accepted the amount. After some time, Mr. R. Ali of Sri Lanka Chandbari under Kolbaha came and tried to give him the cash money, to which he refused to accept. Finally, Ghulam Nabi Azad came and approached him with the money. He had refused to accept the cash money, but he forcibly put the cash money in the delinquent's hand. This is his statement. This was forcibly given to him. It needs to be mentioned that Ghulam Nabi Azad left the room. A team of BSC, thereafter, they came and recovered the money. Lordship. Thereafter, what happened, Lordship? This, during the proceedings.
No, what is the ground on which you are challenging?
Yes, Lordship, there are certain.
We are not the appellate authority.
Yes, Lordship. Firstly, Lordship, this is the written statement. That is, first thing is the written statement. Then second thing, Lordship, ex parte statement has been recorded, Lordship, when he was in an accident, Lordship. This is, Lordship, in.
What do you mean accident?
Lordship, when I had faced an accident, that is in, Lordship, page number 29, Lordship.
Before, all right, you get the records, let us see the records.
Yes, Lordship.
Get the records.
Yes, Lordship. The delinquent failed to turn up because he had
let us see the records.
Yes.
The petition is before the court. Petitioner before the court has received the dismissal order, as also the appellate order. Stop. The records pertaining to the disciplinary proceedings, they call for perusal of the court if the need so arises. Is this matter again?
Month of
August.
Lordship, if it is after the vacation.
Not in July, August.
Earlier also, the lordship, 4 times it has come. They also did not have the record at that point of time.
So
Last time also, they had the record, but they were not.
No, the record,
let it be in the month of July and your relevant records we kept for perusal of the court. That needs to. We'll have it in August. better,
Lordship.
Because July, we are not having the dockets.
Lordship.
We'll see. Based on the month in the third week of July, third week of August.
yes, yes.